42. Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be listed. The matter will be listed on 24th March.
May I please also? I have to mention item number 40, Lordship.
Huh?
Item number 40.
40, yes.
40.
Yes.
Conducting counsel having some personal difficulty, Lordship. I'm seeking for adjournment for today, Lordship. Any day after 1 week or 2 weeks.
On the prayer of the learned counsel appearing for the appellant, let the matter be listed. On 18th March. The learned counsel appearing for the accused applicant submits that the matter has been wrongly listed in admission column. Rather, it should have been. Why? Motion matter. It has come in bail hearing. A new matter. Okay. Submits that the matter has been wrongly listed in the bail hearing column rather than it should have been. It should have come in motion column. Later matter will be listed in the next week on next week on 2nd.
May I please, Your Lordship? Also, I beg to mention item number 19, Lordship. In this matter, Lordship, case diary is not available, Lordship. The date may be fixed.
Okay, CD not received. Let the matter be
19th.
listed on
This concern.
19 March. 19th.
Deeply obliged.
24, yes. Not received. Updated CD not received. Let the matter be listed on 19th March. Interim order so passed earlier shall continue till the next date of listing.
May I please, Your Lordship?
Yes.
I beg to mention for listing up to anticipatory bail, Lordship. To AB, Lordship. Kindly fix on tomorrow, Lordship.
Not tomorrow.
Lordship, file on 12 February.
No,
Lordship.
tomorrow not possible. On 2nd of March.
Obliged.
Item number 12. On the prayer of the learned counsel appearing for the accused applicant, let the matter be listed on 12th March.
May I please, Lordship? Lordship, I beg to mention for listing on regular bail application, Lordship. On tomorrow, Lordship.
Tomorrow not possible.
Motion matter.
Let it be on 5th. 5th.
Other side, there's no mention either firstly.
38 and 39. On the prayer of the learned counsel appearing for the petitioner, let the matter be listed on 24th March, both the matters. 24th March. Item number 30? 34, yes. Okay. On the prayer of the learned counsel appearing for the accused appeal applicant, let the matter be listed on 7th. Let the matter be listed on 11th March.
May it please your Lordship? May it please your Lordship, I beg to mention for listing, Lordship, this is the second bail application, Your Lordship, with fresh ground. Can it be listed tomorrow, Lordship?
No, tomorrow. On 2nd.
Sergeant. My listing. For withdrawal, item number 43.
I'm being called here. No? I'm-
Item BA.
Yes.
It was arrested on 6th of December,
Hmm.
84 days.
Hmm?
84 days. And the affair is that the informant will at midnight, while on sleep, some unknown mistake entered in the house and using some spray, that's number 2, unconscious, they taken some article and 24,000 feet. And forwarding report that is case 60. There were 7 persons was arrested, the present pistol is number 7.
Hmm.
All the accused persons were only released on bail, but it was only 3% released on this, some more the day show. His present prisoners, his role is that one of the accused persons who is the relative one. Sometimes we talk about telephone,
Hmm?
on that ground only arrested, possible to positive this small and other 2% will not released by the after graduate circular. Accept the present all the this.
Mr. Parasar, we have already granted.
My lord, yes, co-accused allowed.
Co-accused allowed 84
days
days.
on length of
Heard Mr. A. Ahmed
And would be
and Uddin, the learned counsel appearing for the accused applicant. Also heard Mr. Ajay Burwa, so and so. This is an application under so and so. One Sri Ajay Shankar Das had lost an FIR on 29/11/2025, alleging that on the night of 26/11/2025, he went to sleep. Some miscreants entered his house by breaking the backside door of his house, semicolon, that after spraying some liquid material on their faces, when the informant and his family members became unconscious, they broke his almirah and stolen gold ornaments amounting to rupees 24,000. On receipt of the FIR, Abhayapuri PS case number 265/2025 was registered. On investigation, the police arrested the accused applicants along with some other people. And since then, for the last 84 days, the accused applicant is in judicial custody. The learned counsel appearing with the accused applicant submits that the accused applicant has been arrested purely on the basis of suspicion, and it is yet to be proved whether the ornaments recovered were actually stolen once or not. He further submits that since the accused applicant has already spent 76 days in custody, his further custodial detention may not be required in the instant case. Therefore, he submits that at this stage, the accused applicant should be granted bail. He further submits the co-accused in the instant, all the co-accused in the instant case have already been granted bail by coordinate bench of this court as well as this court. Full stop. Mr. Arjavur, Mr. A.K. Parasar, then APP on the other hand, submits that there are incriminating materials against the accused applicant in the case diary, accused applicant. Accused applicant, full stop. Therefore, he opposes the bail at this stage. This court has heard submissions made by the counsel appearing for the respective parties, taking into account of the fact that the other co-accused persons have already been granted bail and the accused applicant has already spent 84 days behind the bars. Is of the considered opinion. And this court is of the considered opinion that further custody retention of the accused applicant in the instant case may not be required. Therefore, therefore it is directed to the accused applicant shall be released forthwith from jail on furnishing a bail bond of rupees 50,000 each 50,000 with a security of like nature to the satisfaction of the court of the learned SDGM in bracket M, comma, not Salmara, comma, subject to the following conditions. The accused applicant shall cooperate with the investigating authority as and when required. And the accused applicant shall not directly or indirectly make any inducement, comma, threat or promise to any person who may be acquainted with the facts of the case, comma, so as to dissuade such person from disclosing such facts before the investigating authority. And number 3, the accused applicant should not hamper or tamper with the investigation in any manner. Next, review of the aforesaid directions, this appears the instant bail application is disposed of as allowed.
SDGM not Salmara অভয় ব্যক্তি। SDGM not Salmara অভয়।
SDGM Nosal Mara is not sufficient.
Sure.
Available will be there required.
Plus not Salmara another also.
Okay, available.
Wow.
Come on. We'll call for the CD. We can discuss. We'll see. We'll see.
Reveal from schedules.
Heard Mr. So-and-so. We also heard Mr. So this is an application under so-and-so. Then you write, the case relates to alleged attempts of murder. Case relates to attempt of murder of the informant by her husband. So call for the CD, let the matter be listed on.
Well,
On 13th.
okay.
Item A,
Here, amongst other sections here, the please also just for city. Short it will be.
heard Mr. So-and-so, learned counsel apparently the accused applicant also heard so-and-so. It is an application under so-and-so. Then an FIR was lodged on 26. 26. Alleging. Alleging homicide of the murder of the informant by the accused applicants, full stop. Call for the CD, let the matter be listed on. Sixteenth. Both.
3 and 8.
Hmm?
3 and 8.
Let the matter be listed along with AB number 416 of 2026. Same order you passed here, and there only you change the number. Take along with 557. 557.
For last 7 months of it.
Hmm?
Last 7 months of it,
Hmm.
more than 7 months. Yes, sir, at least 14 months.
At least as TCM commercial quantity.
No, but can we see clear violation of section 48 of BLSS?
Okay, heard Mr. So-and-so, and also Mr. Parasa. This is an application under so-and-so. The case relates to recovery of recovery of recovery of what? Codeine.
Yes.
Recovery of commercial quantity of codeine phosphate and tripoliden, tripoliden HCI syrup. Full stop. Call for the CD. Let the matter be fixed on 23rd, 23rd March. No, there is no, I mean, the full, I mean, I've checked this. All matter, all booked already.
16 was.
16 will be difficult, lot of matters already. I've kept it here. So, see, don't insist. I've seen this, after seeing this, I'm giving, I cannot give you preference to your case. So many cases are there.
Full,
This case, my lord, is have been tagged with item number 16, my lord, same case diagram.
16 also.
Whether the ID is, I think.
16 is bill hearing.
at the time of bail hearing, malaki.
So we'll take it up at the same time, so.
Five. Motion AB.
The SR may be showing at least 10 loss. Right. The petitioner is the manager of the reverse center. And the resolution is that my lord,
We'll call for the CD in that case. But so and so, learned counsel, also sends, Mr. Parasa. Then you write, this is an application. An FIR was lodged on 24/12/2025. Allegation that the informant's son was admitted, the son was kept in Nava Prabhat, NAVA, Nava Prabhat Rehabilitation Center of one.
Mafidul Chaudhury's own house.
On Zulfikar Ali, on, who owns this? Who owns the center?
my lord,
No.
the present petitioner.
You are saying manager?
Mafidullah,
In charge, my lord. In the FIR, they said owner.
No, he is the owner or what?
My lord, manager, in charge. Manager, in charge.
his own house it is running, Malik. That's what-
Owner of, like, owner of the so and so. However, after 3 months, he was found to be critically ill, and there were allegations, there are allegations of torturing the son of the informant. Call for the CD, let the matter be fixed on. On 16th. 16th.
Six.
And possible का थोड़ा time भी कुछ.
Who is your senior? Huh?
Seven.
This lordship pertains to some of the cases lordship has just disposed of by this Monday lordship. Same FIR. It's an anticipatory bail lordship. Lordship will find the FIR at page 11. So the case diary is still here lordship because Lordship has disposed of some of the. Feel for interim.
Hmm?
Just fix for case diary and a short video.
Okay,
If diary is there.
heard Mr. So and so, also so and so, it's an application number so and so.
Person, by that side.
Yes.
This is, the case relates to recovery of cattle. Case relates to recovery of alleged stolen cattle. Call for the CD, let the matter be fixed on.
Maladan short date 11 mala. If possible.
11 is, okay, 11.
March.
Put it on 16th.
Mala.
11 will be difficult. 16th.
Petition under 31 days in custody was released on interim bail.
Hmm?
After 31 days in custody, Lordship,
Hmm.
he was released on interim bail, Lordship. Lordship, kindly, city was called.
CD malot not received.
Lordship, kindly see last order. Last order.
I was seeking another date, malot. Yesterday we received a signal, malot. Yesterday we received a signal from the IO malot is seeking another date, malot.
Lordship, kindly see that it is 11/2 of 20.
No, I have seen this, I've seen this.
Today is 9th day, Lordship. And Lordship, he was granted an interim bail by this honorable court. And as a law-abiding citizen, when he went to police station, because this court directed to appear within 3 days. When he went there, it is such a heinous previous crime of Dakati and so, he was soon arrested. Assuming it to be true, Lordship, when he was arrested, at least for 2 days or 1 day of police custody and interrogation was needed. No. He was made to sit in a whole day in a police station, then to a judicial custody. He is a philanthropist. His father was a landowner of ME school and LP school of that place. And also, Lordship is due to this political.
Okay, we'll put a short date, huh? We'll put a short date.
Lordship.
I understand, but I mean, what is, I mean, Mr. Parasar, why, so many times?
Lordship, this highest statement, Lordship, I can, is reflected in the forwarding. Whatever he stated, that contradictory itself in this election. He says that I have a some criminal. This man was appointed by the Superintendent of Police as a BDP secretary. He says in the FIR that this man was named in the FIR, but in the FIR itself it should unknown. Each statement in the FIR. Kindly see, Lordship, in the forwarding report itself is reflected. He is a veteran criminal. First, in the first page 29, third line, we are prepared to remand him to judicial custody. No for interrogation or any police custody. Next page, page 30. Paragraph 4. He is a veteran criminal. Which I covered kindly see a veteran criminal Lordship and SP gives him makes him a veteran BDP secretary in Annexer, page 12, Annexer A.
The other case was there, malot, because of 320.
Okay, we'll give a short date, last opportunity.
Page 31.
Mr. Parasar, what
Malak.
is happening there? I mean,
Malot, they are giving malot from Kasar, malot, the signal yesterday we have received, informing that the iOS of the kitchen engaged in law and order duty because of that could not unable to send the CD today. Kindly fix another date. Malot,
Page September this page is pending.
malot.
heard,
Most urgent.
heard Mr. N.S. Laskar, the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, and a DP for the state. CD is yet to be received. Yet to be received in spite of at least 7 reminders, full stop. The learned APP submits that he received a message from the concerned IO asking for some more time some more time. Full stop. Let the matter be listed on 2nd of March as the last opportunity to
Matlab-
produce the
Matlab from
CD.
Kasar, matlab kindly, matlab 5th or 6th, matlab.
No, you tell your CD, I mean, tell him to bring
From-
it. No,
From
no,
Kasar.
he has to bring it on 2nd. I mean, why, I mean, 7, 8
Oh,
times
yes,
he's the.
most
No,
of
he has to bring it. Tell him that he has to bring it. On 2nd, he has to bring it. Kasar, it takes only one, Mr. Parasar.
matlab,
It takes one night to come.
no, no, yes, yes.
He has to bring it. Fix on 2nd. On that date, if the CD is not produced, then this court will take up the matter for disposal and pass appropriate order against the concerned IO.
Much
No.
obliged.
9 times, Mr. Parasar.
Yes, yes, matlab. And simply saying that law and order duty, matlab.
No, that, you tell him to come,
but-
otherwise. Personally, I'll ask him to come here. Okay, next time.
Got arrested on 2025, and he has been.
13, no?
On
13.
another by order.
CD has come.
Matlab,
He was in a custody for 33 days. And after 33 days, he released from green bed. My lord, after release from the bed, he appeared and
What is the offense?
offense is just time 8 years.
Mr. Borua.
We have received the case diary, my lord. Victim is mother aged about 18 years, my lord. And she said that, my lord, from last 4 to 5 years, my lord, they are having love affairs, my lord. And my lord, she became pregnant my lord, during the time of losing the-
Let him go.
Now he refused to marry her, my lord.
Let him go. All these things are heard Mr. A. Manaf, the learned counsel appearing for the accused applicant. Also heard Mr. Ajay Boral and AP for the state. This is an application under so. The case arose out of an Ajahar dated 8/12/2025 lodged by the victim woman stating that after inducing him to a relationship, the accused applicant had sexual relationship with him, and due to which she got pregnant. It was alleged that after that, the accused applicant started avoiding her and refused to marry her. Full stop. The coordinate bench of this court, by order dated 9/1/2026, has granted interim bail to the accused applicant, and in terms of the aforesaid interim protection, the accused applicant has already appeared before the investigating officer and recorded got his statements recorded. Full stop. Therefore, he submits that the interim bail so passed earlier should be confirmed as he is willing to cooperate with the investigation. Full stop. Mr. R.J. Burwal on APP, on the other hand, submits that there are certain incriminating materials against the accused applicant of inducing the victim girl who is 18 years of age. Therefore, he opposes the bail. He opposes the confirmation of the interim bail at this stage. This court, after revision of the case diary, as well as hearing the submission of the counsel appearing for the respective parties is of the considered opinion that the interim bill granted on 9/1/2026 should be confirmed accordingly. Accordingly, this anticipatory bail application is disposed of by confirming the interim protection dated 9/1/2026 of this honorable court. At court in the same terms and conditions as stated in the aforesaid order. Full stop.
Fourteen, my lord, PCR was called for, my lord. Only problem is that, my lord, service report we have not received, my lord.
Hmm?
Service report we have not received, my lord.
Service report.
Third time, we are taking time for service.
No, we are not saying for time, my lord. We have only appraised the court that we have not received the service report.
Two times already service not.
They are just intimating. They are not taking, I mean, they are not saying anything. They are not person responsible to serve the notice. Correct? So you be clear when you submit something. Don't make any allegations to your colleague. Just like that. He doesn't go himself to serve notice. Go will appoint somebody.
My lord, my lord.
Heard Mr. R.K. Mondal, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Burwal and the APP for the state. The office note dated 24/2/2006 reveals that service report on respondent number, service report of service of notice on respondent number 2 is yet to be received. However, it is seen that that steps for service of notice was taken on 31/2026. 31/2026, full stop. Taking into account the aforesaid facts, this court is of the considered opinion that an amicus curiae opinion that an amicus curiae should be appointed in the instant case to represent respondent number 2. Accordingly, Srimati Sangeeta Khatamya is appointed as the amicus curiae to represent the respondent number 2 in the instant case. But the matter will be listed on 18th of March.
My lord, 15 also, my lord, TCR was called for, my lord, but
Hmm.
service report is not, we have not received the service report.
You write the same order. Heard Mr. Jailoskop. Write the same order and appoint Akasi Neug. Amicus is amicus. Learned counsel. Amicus. And fix the matter on 17th.
16 with 44.
Can you take up item number 44? It's a second bail application, my lord. The lordship has earlier rejected this bail application that the lordship will find on page 23.
Yes.
When implement in the rejection order, my lord.
Hmm.
Under the new ground which I have taken the petition is that, my lord. The lordship comes to, my lord, page 20, my lord, page 20.
Yes.
Page 20, my lord, this is the arrest memo, my lord.
Hmm.
Where, my lord, the signature of the attesting witnesses is not there. Page 20 and 22, because there are two petitions.
Mr. Borua,
Well, I'm just verifying, my lord.
see,
Second ground, my lord.
hmm,
In the instance is, my lord, 50 numbers of soap boxes containing heroin was recovered by him. Now, my lord, what they have done, my lord, the sealed narcotic drugs were taken out from the respective 50 soap boxes and they made, my lord, they make a homogeneous, my lord, picture. Technical point, my lord.
36 not, my lord. Signature of the witness is not available in the area.
we'll have to allow him, so. Because we are, 36 violation is,
Order unfair logic and on paragraph 5, my lord, the same text.
It's a different. My lord, para 6 maybe, my lord, of the objection on their side said that, my lord, it was seized from their position, my lord. That is why, my lord, signatures are not taken.
Hmm?
Para 6, my lord.
Witnesses are not present, so how the seizure was made? You tell them, they are not to write this kind of things. No witnesses are there, then say how the seizure was made. For seizure, you have witnesses, but for to sign this thing, you don't have witnesses. Heard Mr. N.J. Datta, the learned counsel appearing for the accused applicant. Yeah, this is this, as far as him,
In all the cases, my lord, my lord, this is the case, my lord, wherein one vehicle was following, my lord. The contraband was in other vehicle, my lord. Then when the previous vehicle was stopped, my lord, they said that the contraband is in that vehicle. Accordingly, my lord, it was stopped at Amingao, my lord. And
correct,
other-
correct, they followed it and
Yes,
put
my
up an
lord.
amendment.
Yes. So, my lord, I have verified, my lord, from all the 4 accused persons, my lord, the 36 has not been complied with. It is not here from the record, my lord. That may be
Heard
mentioned,
Mr.
my lord.
N.J. Datta, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Borwal, learned APP for the state. This is an application you write. Then you write para 3 from here, page 24, you write para 3. The learned counsel appearing for the accused applicant, Mr. NJ.com, Mr. The learned counsel appearing for the accused applicant submits that 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 an earlier bail application moved by the present accused applicant, accused applicants to applicants was rejected by this court on 19/2/2026. However, at that point of time, a relevant legal issue was not taken up and not taken up and not taken up in the not taken up, and the instant application has been filed to bring to the notice of this court about the statutory lapse on the part of the arresting authority in arrest of the accused applicant. Full stop. He submits that while arresting the accused applicants, the mandates of section 36 of BNSS was were not complied with to the effect that no signature of any independent witness or any family member of the arrested persons were taken while preparing the arrest memo. He submits that in that ground only, the accused applicants should be granted bail at this stage. In this connection, he has referred to some of the orders passed by this court. Full stop. Then you write 5 from here. Next paragraph, write 5. 5 you write 6. Then you write the APP. The APP, on the other hand, submits that on the other hand, on the basis of the his diary, submits that though signatures of the accused applicants were not taken during the arrest memo, the contraband materials were seized from their possession only. And since they have committed an offense under NDPS, and quantity recovered is of commercial quantity, they should not be allowed to go on bail at this stage due to the rigors of section 37 of the NDPS Act. Then you write this court has produced the case diary and seen that no signature of any independent witness or any family member or any respected or a person of the locality locality is present in both the notices, both the arrest memos prepared by the arresting authority while arresting the accused applicants. Full stop. Then you write 8 from here. After this, then write 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 18 also you write, you make it accused applicants. And the case number has to be changed, huh? And this, which court is this?
Special judge, Kamrup one.
It will be a satisfaction of special judge Kamrup. Kamrup, Amingam, special Kamrup, Amingam. And you put the case number will be different, huh? In the conditions, there are case number is mentioned, that has to be changed. And you make these photocopies of other cards, driving licenses, you make this plural, okay? And others will be same. You just type it out and I'll see.
Special judge within bracket, ND.
Special just in bracket NDPS, Amingam.
Same manner, but this is the first figure.
Okay. Then you don't write that this is a second bail application, you don't write. Other submissions you keep seeing. And arrested at the same time, same listing.
From their possession, contraband was recovered.
That your submission I have recorded. That this is recovered. But you tell your police officers to be vigilant.
One thing,
Mr. Dotto is having a smile.
if I go with my Wi-Fi, I commit a crime matter, my wife has seen that crime matter. But it's the duty of the policeman to serve a copy to my Wi-Fi. They cannot say whether my wife has seen that crime.
No, that depends, Mr. Dotto. I mean, that argument is there. I mean, that statute has said so.
Yes.
But now, I mean, whether practically, I mean, that is required or not, all this circumstance has to be seen. Circumstance has to be seen. But-
Yes, yes.
17.
17, PCR was called for, that has been received. Only service report not received.
The only one thing that's true, my friends, we don't have any doubt about this survey. But this is violation is there, go there, your worship, there, the presence of other.
No, that, I mean, somebody has to be there on the other side.
Worship finds my own. The condition is taken by the time.
But still, I mean, we'll wait for some time.
That's maybe,
This is only second, only the first date.
that's true, my.
Let it go.
Very serious.
No, I mean, we'll have to hear the other side.
No,
It's a POXO matter.
But after 1 week, my FIR has gone.
See, I mean, this was taken only on 2029. Sorry, on 19. Only, Mr.
Condition matter, you worship.
No, I understand, but you understand the court's position also, because,
Madam, 9-2.
Hmm?
So 9-2.
no, the step was taken on 19 too. My dear counsel, you take steps so lately and you point out to your senior, you brief your senior properly. 19 to only the steps were taken. It will, yeah, at least it will take 10 days time to go there and like serve it. How can it be?
Just give your worship.
Yeah, I will wait for one more date. Then if nobody comes, then we'll appoint him. It's only the second date. Because this is the statutory, this thing, we cannot, POXO matter. Heard Mr. HRS already, the learned senior counsel, assisted by also for the accused applicant, also heard Mr. Rajya Boro, learned APP for the state. Though those steps in the instant case has been taken. No, actually what has happened is that on 11th steps were taken. Then on 19th, I mean, requisition for TCR was sent. So there are 2 dates. Okay, but because we are 11th steps were taken. I stand corrected, but 19th, the TCR was called for. But anyways, we'll give one more date. Though those step was taken on 11/2/2026, none appeared for the respondent number 2 as yet. Service report of receipt of service report of service of notice on respondent number 2 is also not received as yet. Taking into account the aforesaid facts, the case may be listed on
These people are very serious, my lord.
Earliest we can fix on 16th.
Then,
No more date. Full,
sometime you lost it.
full.
Yeah, here's what it is. Sometimes, some cases may need some consideration.
Okay, we'll put it on 11th. 11th, not, there is no time. 11th. Let the matter be listed on 11th.
Time being item number 6.
Four eighty-two application. Petitioner was the relationship manager of this bank. Base 15 is FIR. Petition is that some customer has been taken loan by showing documents or without documents.
Okay, we'll call for the CD. Heard.
Loan my lord. In my lord, technically proceeding was initiated against me. But in my lord, I have initiated to my lord case 20 procedure.
No, we'll call for the CD in this case.
And already I cooperate like I noticed was start and I can already given 724.
Where page?
Page my lord, page 24.
24.
Yeah.
It's a departmental proceeding.
Yes, and what is role my lord? That is clearly stated. Page 25 my lord. Para room. Page 26 para room. Was observed that in some of the cases you did not sign the seal to the report, although you were visited the customer's address. Instead, you would allow the edit report to be signed by Procantola RE, who had signed mentioning his name and initial. The my fellow officer. Our signature was given, where my lord I allowed. And next also my lord, there are 3 who uploaded all the loan documents, retention and post-income secret application where you are, wherever that these loans are getting proceed on your transaction and take till that was not signed by my fellow officer.
Disciplinary proceeding is no way connected with the matter criminal case. Disciplinary proceeding is no way connected with the criminal case.
But my lord, statement was given, my lord, my lord, notice was given to 2024. Yeah, sir, I cooperate to the investigation.
You've already suspended.
Yes.
This is a case of 2024, my lord. It is almost, my lord, now it is more than 2 years, my lord. So let the, my lord, will take out the instruction, my lord, what is the stage of the investigation, my lord.
Till today, search has not been finding.
Till today, search is now, where is the apprehension now, my lord, after 2 years, my lord?
It was sent, case 34. Recently. Orders wrong, my lord, I have paid now. Yeah, yeah, 2024. My statement also recorded.
So Borua, let him go on interim. We'll see.
My
Long pending case.
long pending case, my
He's already appearing in the department proceeding also. Already suspended. Heard Mr. M. Kolita, the learned counsel, appearing for the accused applicant. Also heard Mr. R.J. Burwa, learned APP for the state. This is an application that you write, okay? An FIR was lodged.
Actually, then, my lord, when he has received this, my lord, notice, my lord, from the IR,
Hmm?
this, my lord, dated, my lord, to 2024 itself, my lord.
Yes.
So why he is apprehending arrest now, my lord, after 2 years?
The vision
Notice, which one?
24. And 34 is returned.
34? Where is the date?
Yes, 34, my.
What's that, 2026?
I 2050.
Okay. An FIR was lodged on 3/2/2024 with the allegation against the accused applicant that the accused applicant in the FIR you were not named, huh? There,
You don't suspected person. They are one my lord, Gopinath Sharma, relation. S3. Suspicion they fight it.
the accused applicant, being the relationship manager, that's rural lending, rural lending based out at Axis Bank Limited, North Lakhimpur branch, in connivance with certain other persons, have granted certain fake loans, granted certain loans without verifying the proper documentation and the field visits, full stop. On receipt of the FIR, police registered North Lakhimpur PS case number 83/2024. Full stop. After the filing of the FIR, he was arrested.
No.
Never arrested, no? No, filing of that. And when you were suspended? Not there. You said that on the basis of the next line, next paragraph, on the basis of the FIR, a disciplinary proceeding has been drawn against the accused applicant, wherein he has been cooperating and he has already been suspended by the concerned bank. He submits that the case that the learned counsel appearing for the accused applicant submits that though the FIR relates to FIR was lodged way back on 3/4/2024. No charge sheet has been filed in the instant case as yet. He further submits that, however, on 5/2/2026, he received a notice from the officer in charge. Which police station?
Wakana,
Officer in charge,
DSP, DSP,
CDSP Dhokokana Lakhimpur, requesting him to appear on 16/2/2026 at 10 AM on receipt of such notice and being apprehensive, he has approached this court for allowing him to go on pre-arrest bail. Full stop. The learned APP on the other hand submits that case diary in the instant case will be necessary for consideration of the bail application, consideration of the anticipatory bail application at this stage. Full stop. Therefore, he opposes the bail application, opposes the prayer of bail. Full stop. Taking into account the whole aspects of the matter and the fact that the accused applicant has already been suspended and he is cooperating with the investigation, cooperating with the departmental proceedings started against him. This court is of the considered opinion that at this stage, interim protection should be granted to the accused applicant. Accordingly, it is directed that in the event of the arrest of the accused applicant, he shall be released on bail on punishing of the bail bond of rupees 30,000 with a security of like nature to the satisfaction of the investigating authority in connection with North Lakhimpur PS case number 83/2024, subject to the condition that he appears before the IO within a period of 10 days of passing of this order and shall cooperate with the investigation. Full stop. Let the matter be listed on March 23rd.
Eighteen, my lord, case diary not received, my lord.
Case diary not received. Case diary not received.
But as per the FIR, there is no specific mention from post possession, this heroin is recovered. Even the lordship, the 14 gram with container.
It's called the Jalukbari case, my lord.
We'll see the NDPS case. I mean, it'd be difficult.
6th of March.
CD not received. Let the matter be fixed on 6. So many cases are there. 6 not possible. 9th. 9th. How many days you have? So lot many days are there. 9th, how many days? Okay, 6th. 6th, no, 6th will be difficult. 5th.
20.
Malad, in which case, Malad, after some time maybe they can, Malad, because what happened, Malad, while seeking the case diary, Malad, perhaps from our office, Malad, it is mentioned as Kolgasia 150/2026. Actual case number of 2025. So we have got a signal that no such case to 150 of 2026 is registered in an employed person, Malad. He is already arrested, Malad. Today is 61 days, I think. So, Malad, I have already talked with the Malad, our office, Malad, to take instruction, Malad. Perhaps such.
So we'll take it after some time.
Malad.
1.
Otherwise, my lord, it's a POXO matter, my lord, service completed. Amicus may be appointed, my lord.
No, Bill, you have MS? MS, I heard Ms. R. Medhi appearing on behalf of Mr. R. Bora, the learned counsel, appearing learned counsel in the instant case, learned counsel appearing for the accused applicant. Also heard Mr. K. Bushra, the learned APP for the state. Service report, we have.
Yes, my lord, we get the service report, my lord.
Mr. The learned APP submits that service of notice on respondent number 2 has been completed.
Joymoti Devi. Well, that may be kept as a part of.
Has been completed, and to that effect, he has submitted.
Service.
He has submitted a service report, which is kept on record, marking X. In view of the aforesaid, in view of service of notice on respondent number 2, and since none has appeared on behalf of respondent number 2, this court is of the considered opinion that an amicus curiae should be appointed to represent respondent number 2 in the instant case accordingly. Accordingly, Nurul Hassan is appointed as an amicus curiae to represent respondent number 2 in the instant case. Let the case be listed on 17th March. 17 March.
Okay.
22.
আছে নে কিবা? কোনে চাইছে?
Is there yes come?
Mr. Borua has gone through that, madam.
Okay.
After some time.
3.
23 আপনি চাইছে?
But,
Mm.
under your document will find the position of 36 has not been followed in this case. And moreover, my lord, you document find in the second accused, motion stage, 36 is not given, 48, 47 is given. But in Rasimuddin's case, 36, 47 not given. 48 is given, it was under the signature of the co-accused. That is also not mentioned.
There are two persons, right?
One person was coming in a different car, but he has been.
No, what are the technical difficulties? I mean, section 36 where? 36, 36 not complied.
Against the accused number 1, 47 is not given, 48 was given, but it was signature of the court case. And 28 days, recovery is over, investigation is virtually over,
Quantity is commercial quantity.
no.
Yeah, but how much?
Intermediate.
Intermediate quantity.
No, I am placing your lordship judgment.
Have we annexed 36?
No, it was not given, how can I annex? That's why it was not given, this, can go be arguing your lordship.
Mr. Parasa, it was not given.
Malad, no, Malad, given.
Hmm?
All are complied, Malad.
36 আছে?
This is 36, arrest memo.
What is the attested signature?
This is the signature of witness, signature of arrestee Raseluddin, signature of Raseluddin, signature of Rahul Amin Madar Bhuya. Rahul Amin is the brother of Rasel. Then signature regard 36, Nomar Hussein. Witness is there, signature is there.
The same person has become the signature.
Same person, maybe Malad.
Then 48.
Witness, 48, I am saying. Lordship may verify, Malad. 47, Raseluddin Madar Bhuya, 47 is there. Then Namaruddin 47 is there. Now Malad 48, signature Rahul Amin. Rahul Amin is the brother, Malad of Rasel. Signature of Raseluddin Madar Bhuya is there. Signature of Namaruddin is there. Rahul.
It is signature number, how can be?
Namar, may
Here is the accused is who? Who is the accused?
accused is here Namar. And it was given to Rahul Amin. Malad, discrepancy, Malad, may kindly verify. I have flag mark.
To me, that's right.
36, 47, 48, all are there, Malad. Here, total, Malad,
What matter was?
15 shot box, around 187 point something gram of heroin, Malad. FSL is not yet received. Only 28 days investigation is going on. One car was, Malad, for the first accused person, Malad, he is coming in this car, in the back side of the Malad car. In the door, Malad, it was Malad kept in concealed position. Second person is coming in the next vehicle. Their statement, Malad mein perus statement of the accused persons in the back side. I have flag mark, Malad. All are there.
Malad, in the second accused was coming in a different car.
Different car, Malad.
That is the modus operandi these days.
Conspiracy has been created against him.
No, Malad,
So
investigation.
these two were connected also.
Initial.
My lord, this is the 21B, your lordship has considered in so many cases, 28 days, I paid the trial, my lord. When recovery is completed, my lord, charge sheet will be definitely filed.
Like this week, I have seen only one case, that is, all are followed, 36, 47, 48, all signature has been given.
Because people different, my lord. Now they have become very cautious now.
Yeah.
We want that to follow. 47, 48 was served to me after 1 day. The law is 48 is forthwith. I was served is on 31. I was arrested in 30th and 11th PM.
Forwarding of 21, 22. Before forwarding, it has to be there.
From the form of 47 matter, a lordship will matter. I was arrested on 30th of January at 11 PM. So the arrest is over and the document and the service notice was served next day, matter. 31.
Before
After
forward,
after 1 day.
before forwarding, it has to be given,
Law is 48 is very clear. What?
The Mihir case, Mr. Biswas, that specifically says that before production of production
Production on
before the
31st.
court.
Production is the 31st. But can we go beyond the?
No,
statute,
Mr. Biswas, I mean that has been clarified in
Mihir case.
Mihir's case. That has been stated that. So
That is the,
we heard Mr. S.C. Biswas, the learned counsel appearing for the accused applicants. Also heard Mr. K.K. Parasar, the learned APP for the state. This is an application in the so-and-so, right? The gist of the case involved in the instant case is that on 31/2026, one SI, Jitumani Boisho of Harangajao Police Station lodged an FIR alleging that on 31/2026, a secret information was received about two persons, namely Russell Uddin alias Motu and Namor Hussain alias Bilal, along with two vehicles with bearing registration number AS01DJ DZ 9081 and AS01FU 2886 were coming from Sribhumi towards Guwahati via Haflong for the transportation of illegal drugs, concealing inside their vehicles. Full stop. On receipt of the aforesaid information, the police team arrived at a place, namely Ditokchera OP at National Highway 27, and started naka checking of the vehicles. Full stop. At about 3:20 PM, the suspected vehicles driven by the aforesaid two persons were intercepted, and on search, the police recovered suspected brown sugar concealed inside the vehicles. Full stop. Concealed inside both the vehicles, okay, both the vehicles. they recovered certain other materials also along with the suspected brown sugar, full stop. On receipt of the FIR, police registered the Harangajau PS case number 3/2026 under the aforementioned sections, full stop. Mr. S.C. Biswas, the learned counsel appearing for the accused applicant, should I record your submissions regarding those 48, 47, 48, these things? Because those are complied with,
Yes, now I.
because if you have not checked properly, your junior also hasn't checked properly.
Document subject to us from that time.
No, I mean, you don't have the documents, but you don't verify it. You should have verified, or you should have taken the certified copies.
Still on that basis I come.
Now you have submitted without having any basis.
No, what with me, my.
No, correct. I mean,
Now they-
now all these things are complied. Yeah, juniors should have checked.
But grab that 28 days behind.
Okay. Mr. S.C. Biswas, learned counsel, appearing for the accused applicant submits that the accused applicants are young boys, and they have already spent 28 days behind the bars, and quantity recovered is also not of commercial quantity. Therefore, the accused applicant should be granted bail at this stage. Full stop. The learned AP, Mr. K.K. Parasar, the learned APP on the other hand submits that that investigation is still going on, the investigation is still going on. And all formalities regarding their arrest have been complied with by the arresting authority in the instant case. Therefore, he submits that at this stage, the bail to the accused applicants should not be granted. After considering the entire facts of the case and on perusal of the case diary, this court is not convinced at this stage to grant bail to the accused applicants. Accordingly, the bail application is rejected.
Pending matter item 20.
Malad, yes, Malad, in this case, Malad, we have taken a following instruction, Malad. CS not yet submitted, Malad. 21B, 60 days is the mandatory period, Malad. From forwarding today, 60 days, but rest 61 days, Malad. Otherwise.
Okay, heard, Mr. AI within the learned counsel appearing for the accused applicant, also heard Mr. K.K. Parasar, learned APP for the state. This is this is an application you write, then you write. An FIR was lodged on 27/12/2025. 25 alleging that police received a reliable information to the effect that a drug peddler was selling suspected heroin at his own residence. Accordingly, a search was conducted at the spot, and during the search, 19 plastic containers containing suspected heroin, total net weight 13.75 grams were recovered. Next para. Accordingly, the police registered Kolgachia Police Station case number 150/2025 under section 21B, small b of the NDPS Act 1985. Full stop. The learned counsel appearing for the accused applicant submits that the accused applicants had been arrested on 28/12/2025 and they have already spent more than 60 days.
From 28/12 today is 60 days.
They
60 days.
They have spent 60 days behind the bars, and therefore they are eligible for default bail in the instant case. Mr. K.K. Parasar, the learned APP, fairly submitted that the charge sheet in the instant case is yet to be filed, and the accused applicants are liable to be released on default bail. Default bail.
Default bail will, default bail will come tomorrow, Malad.
Okay, you're right, but charge sheet is yet to be filed, and today is the 60th day. Today is the 60th day of their arrest. Full stop. taking into account the submissions made and submissions made, this court is of the considered opinion that the accused applicant should be released on bail at this stage. Accordingly, it is directed that there is one person,
One person.
all applicant, or applicants, that the accused applicant shall be released forthwith from jail on furnishing of a bail bond of rupees 50,000 with a security of like nature, subject to the satisfaction of the special judge Borpeta, subject to the following conditions. You put those conditions, NDPS cases conditions দিয়া আছে না লৈ ল'বা আছিল না আছে না এইটা লৈ ল'বা in terms of the aforesaid direction the instant bail application is disposed of.
Like.
245.
Charges submitted in the present case process, charges are filed on 27/11/2025. 27/11/2025, charges were filed. And 15 witnesses were shown in the charge sheet. But till then, no witness has been acknowledged.
My lord, before my learned friend submitted, my lord, one thing I think to notice, my lord, is a POCSO matter, my lord. Otherwise, service completed, my lord. And my lord, that is the for the respondent number 2, on earlier 2 occasions, my lord, the learned counsel appeared in the matter, my lord. But
Oh, this is the same matter.
my lord, but thereafter, my lord, he didn't appear, my lord. So at this state, today is also not appearing, my lord. On earlier occasion, my lord was.
Then we will
fifth
appoint
time appointed
a
amicus. That is my only humble say.
Heard Mr. A. Ahmed, the learned counsel appearing for the accused applicants, also heard Mr. K. Boiswa, the learned APP for the state. It is seen from the records that Mr. R.I. Gogoi, learned counsel, appeared on behalf of respondent number 2 on 2 occasions, that is 9/2/2026 and 10/2/2026. However, after those dates, the aforesaid counsel did not appear. Counsel did not appear on the last occasion, that is on 24/2/2026. And he has remained absent today also when the matter was called for. In view of the aforesaid, this court is of the considered opinion that an amicus curiae should be appointed to represent respondent number 2 in the instant case. What is the list? It's gone somewhere. Record was given me before my group. Okay, accordingly, Mr. S. Accordingly, MS Trisa Sharma, the learned counsel is appointed as amicus curiae to represent respondent number 2. The learned counsel appearing for the accused applicant shall serve a copy of the application, copy of the bail application to the amicus curiae within 2 days. On passing of this order, let the matter be fixed on.
On second month.
No, not possible second month.
For last 2 occasions, lordship, that he appeared and says he will appear for the.
Then I bring him, put him behind the bus.
Before filing wakalat kama it took time, lord. Because of that, this case is.
We are fixing it on 11th 11th of March. Not possible, sir. I would have given otherwise. So many, I mean, every day 30 cases already being posted.
25, bail hearing.
Safety is object. Object, on the last occasion, the CD was called for.
CDS come. Why CD hasn't come?
My lord, that's
Six occasions.
last time, my lord, only short.
This is, I mean, in a couple of other cases also, we have noticed that
My lord,
CDs are not received
my lord,
after 6-7 dates also.
my lord.
So we'll have to call these officers then.
25.
25/9, it was, or the first order was passed. Heard Mr. GK Gogoi, the learned counsel appearing for the accused applicant, also heard Mr. K. Bushra, learned APP for the state. It is seen from the records that in spite of reminder for the CD for about 7 times, on 1, 2, 3, 4, 5, 6, 7, on 7 occasions till date, the CD has not been produced. Full stop. Learned APP is directed to take instruction as to why the CD has not been sent by the IO till date. In the event of not producing the CD on the next date fixed, this court will take up the matter on the basis of the materials produced before this court and shall be compelled to take appropriate action against the IO, against the concerned IO. One second. Interim order so passed earlier. So interim order was there. So we'll do one thing and we'll confirm this. I mean, what? I'll just come back in 5 minutes.
My Oh, but it-
What was written last? When do we fix it? Yeah, I mean, offense is,
My lord, 1031.
oh,
That-
that's
that-
why, I mean,
Because of
but
that.
this is not the way to do it.
Yes, my lord. Yes, my lord. Very short accommodation and it will be reflected, my lord. I will communicate the same. The
Let
order.
the matter be fixed on. Interim order to hearing, no? Interim order so passed earlier, shall be extended till the next date of listing. Then let the matter be fixed on 5th of March.
5th of March, my lord. Deeply place.
Timing item 22.
Case diary received, my lord.
Okay. He arrested on 27/1/2026. Yes. How much is the quantity?
1 kg 0.75 grams.
Of what?
Tablets.
Yeah, Yaba tablets, my lord.
So it's more than commercial.
Commercial, commercial.
My lord, there is 56%. Average page number 17.
Hmm. You're appealing for all three?
No, my lord. I'm appealing for accused number G, Muktadir Ahmed Baldwin.
Hmm. Yes.
Here, house was conducted in the house of number 1, that is Shahjahan Ahmed.
Hmm.
And the police has recovered the said alleged contraband mine.
Hmm.
There, my lord, in my bail application,
Hmm.
in para number B, my lord,
Hmm.
I have stated,
Hmm.
para 8 of my bail application.
Tell me.
The accused number 2, my lord, is Kamran Hussain Baldwin,
Hmm.
is the son of the present accused petitioner.
Hmm.
And my lord, his son, my lord, is a drug addict, my lord, and he was in rehabilitation center for a period of 1 month, my lord, in the year 2025. And I have annexed also a copy of the rehabilitation center certificate, my lord, annexal 5, my lord, page number 36, my lord.
Hmm.
On the day of the alleged incident, my lord, the present petitioner,
Hmm.
he got the information that his son again go to the house of the accused number 1, my lord, to procure the drugs. And out of the parental concern, my lord, the present petitioner, he immediately visited the house of the accused number 1, my lord, to bring back his son, my lord. And on the spot, my lord, the police has arrested the present accused petitioner only mere on suspicion that his presence in the state place of occurrence, my lord. The present petitioner, my lord, he is not involved in trafficking, my lord. Nothing has been recovered from the complete condition of the present petitioner, my lord, and he is not related to any offense, my lord. So I have stated in my paragraph of my bail application, my
Mr. Borua?
Yes, my lord, we have received the case diary, my lord. From the seizure list, my lord, it was recovered from all the 3 accused persons, my lord.
The
Because
accused
my-
persons means, 1 to 3.
1 to 3, my lord. Shahjahan Ahmed, Hamran Hussain, and Muktadir Ahmed Baldwin, that is the present petitioner, man,
So but he's from, recovered from him also.
of him also, man, as per the seizure list, my lord. And seizure witnesses also implicated, my lord. Seizure witnesses have also implicated, my lord.
Thanks, Abhi.
Hmm.
My lord, it's number 25.
Hmm.
The seizure list, my lord, is dated page 25, my lord.
Hmm.
Description of the seized article.
Hmm.
Here, my lord, total 1 cream color plastic red box containing 5 numbers of packet. That is, my lord, all the 5 packets in 1 box. And if your lordship kindly peruse the FIR, FIR page 17, my lord.
Hmm.
Last second para, my lord.
Yes.
The police appeared at 4:10 p.m.
Which paragraph?
Last from the book.
Page 17.
Page 7.
Yes.
At 4:10 p.m., the
Hmm.
police staff apprehended Shahjahan Ahmed, accused number 1,
Hmm.
the house owner who attempted to flee. Other person escaped. The 2 persons apprehended inside the house disclosed their identities as Kamran Hussain Baldwin and Muktadir Ahmed Baldwin, both the residents of so and so. During the preliminary question, all the three appear nervous and evasive and fail to provide any satisfactory explanation for their attempt to plead and raising strong suspicion of illegal activity. Now, thereafter, my lord, notice under section 50 was served, and they have given consent and probably both were served. Now, it is at 4:10 p.m. Now, my lord, I will turn to page 18, my lord. At 4:30 p.m., my lord, a thorough search of the house was conducted, the house of the accused number 1. During the search, one box was recovered. And on opening a dark cream colored plastic box was found containing 5 plastic red packets. So, my lord, that at 4:10, where the body was searched of the present accused petitioner, nothing has been recovered from the present accused person, my lord. And at 4:30, when the house was searched, because the raid was conducted in the house of accused number 1, and he is dealing this death of alleged offense, my lord. And I have already stated in my investigation my presence in the court, my lord. Why I am present, and also annex the copy of the rewritten certificate of my son, my lord. So my submission before the Supreme Court, my lord. We are present at the spot, my lord.
Okay, heard, Mr.
I'm a DJ Hall.
BJ Haloy.
DJ Hall.
DJ Haloy. The learned counsel appearing for the accused applicants also heard Mr. R.J. Burwa, the learned APP for the state. This is an application under so and so. An FIR was lodged on 26/1/2026, alleging that on receipt of specific and reliable information that regarding the presence of some unknown persons involved in illegal trafficking stroke dealing with NDPS drugs at the residence of one Shahjahan Ahmed of Harinagar Part 3, the police team went to the aforesaid went to the house of the aforesaid Shahjahan Ahmed, and after reaching the spot, they found 3 persons, namely Shahjahan Ahmed, Kamal Singh Borvia, and Muqtadir Ahmed Borvia, while another person named Jiabur Borvia managed to escape. Full stop. It was alleged that during the search from the house, 10,000 suspected Yaba tablets weighing 1.075 kg was recovered. On receipt of the FIR, the police registered Katigora PS case number 2/2026 under the aforementioned sections. Full stop. Mr. Halo, the learned counsel, appearing for the accused applicant, submits that the accused applicant who is no way involved in the instant case. In fact, the accused applicant's son, who is also a co-accused in the instant case, is a drug addict and in the habit of visiting the house of the aforesaid Shahjahan Ahmed for procuring drugs. Full stop. He submits that on getting information that his son may be visiting the house of Shahjahan for procurement of drugs, he went to the spot, and at that point of time, police came and arrested him on suspicion. He submits that he referred to a certificate. He referred to a certificate issued by one New Life Foundation, a de-addiction and rehabilitation center, to the effect that his son, namely Kamran Hussain Barbuya, was admitted to the aforementioned center for some time for his problem of substance use. Therefore, he submits that no contraband material was in fact recovered from the conscious possession of the accused applicant in the instant case, and he has been arrested merely on suspicion. Full stop. The learned Mr. R.J. the learned APP, on the other hand, submits. Let me see that forwarding report.
My lord, my lord.
Submits that there are there are sufficient incriminating materials against the accused applicant of his prima facie involvement in the offense as narrated in the FIR. Therefore, at this stage, he opposes the prayer of bail of the accused applicant. And statements are also there.
Yes, statement also there.
I mean, Mr. Counsel, you're making a false story. You're making a false story. I mean, statement of, the present applicant is totally different before the police. You're making a false story. You get proper instructions from the client. Because making a false story puts you in difficult position. There's a totally different story.
My lord, assuming my lord is whatever he has made.
No. I mean, while submitting, if you make a false story, then becomes difficult. I'm not blaming you, but like that, maybe the instructions were not correct. In fact, he went for a different purpose. The purpose was saying that like, he got to know that he is going to procure some drugs and all. It was not not the thing he has stated in his statement. He stated that he stated that he is innocent, but he is saying that he went for a different purpose, not for this. So that those kind of things will, be difficult to consume by this court. Okay, last line. Opposes the bill. Opposes the bill. This court, the case diary in the instant case has been produced before this court. And the same is produced. On producer of the case diary, it is seen that there are certain incriminating, and there are sufficient privacy incriminating materials about the involvement of the accused applicant in the instant case, as well as the story that has been narrated in the in the bail application. Is a bail application by the accused applicant is prima facie found to be incorrect. And therefore, this court is not, um, not convinced at this stage that the accused applicant should be granted bail. Full stop. Accordingly, the instant bail application is rejected.
Item 26.
So that creates a doubt.
Twenty-six, my lord, case diary not received.
Is there not received?
Case diary not received.
But Mr. Borua, the allegations are not such.
He's on interim, my lord, for some time.
Okay, is there not received? Interim order so passed earlier shall continue till the next date of listing. Let the matter be fixed on 18th.
15.
18th.
18.
18th.
27 to 7.
The TCR has come.
TCR has come, my lord.
Yeah, my name is not there in the complaint. Main accused who is the one, the domestic, when I know, he is forwarded to the court file after the trafficking.
Hmm?
And the other two accused have been named in the affair, but I am not there.
Hmm. Hmm.
My name is in the complaint.
Your name has been implicated for what? Page, FIR?
Page 10. One people taken on the taking.
Your name is
My name is Nazim Ali. Nizam Ali alias Nazim Ali.
Nizam Ali Nadim Ali. So your name is not there.
In the affair.
So how you got implicated?
Once was taken also, I was explained, that is also there also my name is not. Actually, the main accused which is when I actually happen to know him, my lord, and I met him in the hospital because 3:30 is also there. Where, but that matter, shopping or thing, my lord, because 3:30, but there is no material that I am involved in it, my lord, regarding the 3:30. And she's already married now to another person, my lord, and this check.
She's married to another person.
Another person. Other two persons who are his family members, many, they are also not Darsikan. So only I am have to face that trial.
Only you are facing the trial.
The other two name accused are not. Although their name have specifically stated that they are involved. We share 5 of the. Here, madam, someone has been issued in the meantime, madam, by order 787.
Charge sheet already filed, no? Common issue.
No, he has been shown abscond in the search sheet, my lord.
But you are also available.
Because he has not cooperated with the getting officer, my lord.
Interim where? Which order? No interim.
I also have to disclose that.
So you're not named in the FIR also.
Neither in the, one,
Mm, mm, mm.
no, which file?
Page number 18 is our 164 statement, madam. Page number 18 to page number 18. Page 18 to page 18. তার নাম থেকে
Who is this person? Yeah, the present applicant, who is he?
He becomes 10 million and he loses the main accused, my lord, and
my lord, maybe
How the implication has come?
clearly within the charge sheet also. But only thing is that the charge sheet is that he was involved in 313, my lord.
Charge sheet as pays, okay, charge sheet.
my lord, page number 26, my lord.
One is, this Noor Islam, he's a juvenile.
Please do it.
Azida Begum, then Rustom Ali. Your name is Nazim Ali, right? Nizam Ali. One second.
That lordship may come to page number 26, my lord. It will be clear from the search sheet.
26.
26, my lord, yes. 26, my lord. Lordship may peruse the second line, my lord.
Second line 26. What is
Page
this?
number 26, my lord. Search sheet, my lord. Vernacular.
What is written here? Which line?
Second line, my lord.
Second line is what? Some legal guardian samji diwa. Hukum diya. What is
Well,
this?
Case number, Fauzi, Aparadi.
Hmm?
Second line, what is this?
Second line, page 26.
Search sheet, my lord.
This is this is
Yes,
the
ma'am.
charge sheet, page 26.
Lordship may open the entire page, my lord. Yes,
Hmm.
the second line, my lord. He has abated, my lord, that means.
His role is to extend only. He was.
I think it's there. Yes, sir. Yes,
Abortion ক্ষেত্ৰত সক্ৰিয় ভূমিকা গ্ৰহণ কৰাৰ যথেষ্ট সাক্ষী প্ৰমাণ সহকাৰে তেওঁকো অভিযুক্ত কৰিব পৰাকৈ সাংটোত
But
সুপ্ৰতিষ্ঠিত হয়.
in her statement, she hasn't said anything like that.
She has not implicated.
He is not implicated.
Then he family members have been not trusted.
He is neither a family member nor anybody. Maybe somebody, maybe he was there.
Because the victim was taken to my lord Sipazar hospital, my lord.
No, in her statement, she didn't say anything.
She has not implicated, my lord.
No, nothing has been stated. Only thing is that statement of victim recorded. Let him go. He'll cooperate with the investigation. He has charged the case, so let him appear before the trial court. Or Mr. Mr. Sahajarika, the landed counsel appearing for the accused. I Hazarika, Mr. Lamin Counsel, appearing the accused applicant, also heard Mr. R.J. Borwal and an APB for the state. Then you write, this is an application under so and so. Then you write, an FIR was lodged on it is a complaint file, right? The complaint was filed on 10/2/20 on 10/2. No. Complaint was filed when? 12/22/1, 22/11. Huh? One to 2019, before the Chief Judicial Magistrate, Dorong, Mongoldoy, by the complainant alleging that the complainant's minor daughter was having a love relationship with the accused number one named in the complaint. But Noor Islam has been, his age is 23 years. At the time of occurrence is like, I'm only, okay, occurrence was 21/11/2018. Long time back. Okay.
Actually submitted in the year 2019 itself, my lord.
19.
Now the court has taken cognizance. Now, I mean, my lord, 7/8/2025, my lord.
Long time, okay, accused number one, love relationship with the accused number one, and during their love relationship, the accused, accused applicant, love relationship, the aforesaid accused number one had physical relationship with with the minor daughter of the complainant. Complainant, full stop. After such a physical relationship, it was alleged that, comma, after such physical relationship, comma, it was alleged that she got pregnant, and the accused number one, along with accused number 2, 3, and 4, had taken her forcefully to a hospital, and thereafter her pregnancy was forcefully aborted. Full stop. It was alleged that since the accused, since the minor girl was not keeping well, therefore the parents, the informant and her informant's family took her to a hospital and found out that her pregnancy was aborted, and she disclosed that the accused applicant number one had sexual relationship with her, and due to that, she got pregnant. She got impregnated. On receipt of the FIR, receipt of the complaint, the same was it was sent to a police station. Complaint? The complaint was forwarded to which police station? Forwarded to Dhula police station, wherein an FIR was wherein an FIR was lodged, and accordingly Dhula PS case number 70/2019 under section 376/313/506/34 of IPC was registered against the accused applicants. Full stop. The police, after the investigation, filed the charge sheet. Wide charge sheet number 121 dated 15/6/2019, wherein the present accused applicant has been charged. Charged under what? Same. Page. Charge sheet, and thereafter charge was framed against the accused applicant under section 376 stroke 313 of IPC read with section 4 of POCSO Act against the accused, present accused applicant.
Only cognizance second, my lord. Charge is yet to frame, my lord, because the appearance of the accused person would be necessary.
Okay, cognizance taken. You write, don't write after filing of the charge sheet, cognizance was taken under swing. Write that. The learned counsel appear, Mr. Ali, Mr. Hazarika, the learned counsel appearing for the accused applicant submits that accused applicant is well connected in the instant case. He is neither named in the FIR nor he was ever arrested by the police in connection with the instant case. He submits that he has been arrested only, and don't write it, that his name has been roped in the instant case only on the basis of suspicion, whereas none of the accused persons named in the FIR has been named in the charge sheet. Full stop. He submits that since charge sheet has been filed in the instant case, he is willing to appear before the trial court and cooperate with the trial. In view of the aforesaid, he submits that the accused applicant should be allowed to go on a pre-arrest bail at this stage. The case diary in the instant case has been received and the same is perused. Full stop. The learned APP, Ms. R.J. Burua, on the other hand, submits that since charges have been since charge sheet has been filed wherein he has been shown as an absconder, the prayer of the accused applicant should not be considered by this court at this stage. Full stop. This court, after perusing of the trial court record and on perusal of the statements of the witnesses, including the victim and prima facie of the opinion that the present applicant should be granted the privilege of pre-arrest bail so that he can appear before the trial court. Full stop. Accordingly, it is directed that in the event of his arrest in the event of his arrest in connection with the instant case, he shall be released. He shall be released by the arresting authority on submission of a bail bond of ₹30,000 with a surety of like nature to the satisfaction of which court is this? Satisfaction of Special Judge Dorong Mongoldoy, subject to the condition that the accused applicant shall. He will directly appear before the court. When is the next date?
7/3.
He will appear before the trial court on 27/3/2026. That is the date fixed. That is the next date fixed in the trial court. That is court league, then a special court. Full stop. in terms of the aforesaid direction, the instant AB application is disposed of.
Look, he is appearing for the informant, madam, since the POCSO case, madam.
Huh?
I'm for the informant.
You have filed a wakalat nama? Your name? It's R.A. Chaudhary, ऊपर में लिख देना, R.A. Chaudhary. Put his appearance on behalf of the respondent number 2. You have anything to say?
My lord, only since summons has been issued for
So he'll appear?
appearance. I-
My lord, notice sir, in the matter, my lord, amicus may be appointed, my lord. We received the, my lord, communication.
Okay. और Mr. So and so लिखो, दोनों का नाम लिखो. Then you write office note. The learned APP submits that notice on respondent number 2 has been served, and to that effect, he has submitted a service report, which is kept on record by marking X. Since none has appeared on behalf of respondent number 2, Srimati Dipti Pathak Net Council is appointed as amicus curiae to appear on behalf of respondent number 2 in the instant case. A copy of the bail application to be served on the amicus curiae within 2 days by the council appearing for the accused applicant. First of, let the matter be fixed on.
CD received, my lord.
On 5th,
If my, CD to be retained, my lord.
CD so received to be retained.
My lord.
Okay, my lord, case that is not received, my lord, IO has paid for some time, my lord.
Okay, CD not received, CD not received. Though Mr. A.R. Sigla, the learned counsel, is present on behalf of the accused applicant, full stop. Let the matter be listed on.
16, my lord. Mr. Mahajo, PS, my lord.
But you'll have to wait for some time, the board is full totally. Okay, we'll put it on 11th. 11th, let the matter be fixed on 11th.
Case that is received, my lord.
Is it received?
Received.
Yeah, one of the full respect. Right now, we have been stopped with an objection application. Yeah, what has happened, madam? Be very precise, madam. Madam, intra-party rivalry in a particular political party, madam. There are two cases existing, madam. One lordship has called for the case diary. With all respect, madam.
The other one hasn't come.
Other one, my lord, prayer was possibly made, my lord, but that was not reflected. Now, my lord, may I just say one thing, my lord? Regarding, my lord, the reverse heart, my lord. One objection right now, it has been filed, my lord. Prior to entering this court, we have received it, my lord. May I place us 3 things before your lordships, my lord. Here, what has happened, my lord?
No, whether the other case there will be required,
Because the witnesses, my lord, police may be siding with someone, my lord.
Hmm.
Because in both the cases, the witnesses are to be the same, my lord. Because same place of occurrence, same time of occurrence, my lord.
Hey. आस्ते इतना जोर से नहीं. यहाँ पे वो चल रहा है, तुम चिल्लाने आए हो क्या?
May I, my lord?
Yes.
My lord, with all respect.
No,
my
see,
lord,
like, I mean, this, your case is
my
relating
case
to
is, my lord,
Nilamboja police case
2026.
5 or 4?
4 is this case, my lord, where I am seeking PRS bail, my lord.
Okay, and 5 is,
Mine.
5 you have lost it.
We have lost.
Okay,
And my lord, we will file a reply to their affidavit, which they have objecting our bail, my lord. That they have filed right now, my lord.
you are going to file.
Yes, we should file possibly.
Okay. Then we'll
And
call for the,
factually-
we'll call for the other case diary as well as let them file the reply
Yes,
in the meantime.
It has also not come in the record also, I think. That is-
and flex.
The case diary he has received, no? One case
The
diary. he has-
relevant case that we have received, my lord.
The other case diary, that is the,
Heard
Yes.
Mr. B.K. Mahajan, the learned counsel appearing for the accused applicants. Also heard Mr. R.J. Borua, learned APP for the state, as well as Mr. S.C. Biswas, the learned
for the informant.
counsel for the informant. It is submitted before this court that that post filing of the FIR, the post registration of the Nilam Bazar Police Station case number 4/2026. Another FIR was lodged by whom?
The first informant side, my lord.
Lodged
Oh,
by
I'm sorry, my lord, the accused person's side.
Accused
Ah.
person side.
lodged by the accused person's side, which is registered as Nilam Bazar Police case number 5/2026.
Yes, yes.
26, full stop. It is seen that though the case diary in connection with Nilam Bazar Police Station case number 04206 was called for and the same is received. The case diary in relation to case diary in relation to Nilam Bazar PS case number 5/2026 was not called for on the earlier occasion. Full stop. In view of the aforesaid, it is of the considered opinion of this court that the case diary relating to Nilam Bazar PS case number 05/2026 is also called for. Full stop. It is also submitted before this court that an objection to the instant case has been filed by the informant, to which the learned counsel appearing for the accused applicant submits that they will file
My lord,
and
done that.
they will file a rejoinder. Full stop. In view of the aforesaid submissions, let the case be listed on
Can it be? I am outside. Any convenient.
It can be done only on 11, not before
Fine.
this.
We'll retain this case diary matter and call for the file.
Then let the case be listed on 11th. In the meantime, the case diary relating to Nilam Bazar PS case number 5/2026 to be produced before this court.
Can I make it? My lord, with all respect, this is just a prayer, my lord. Here, my lord, apparently what they had, my lord, with all respect, placed before this court, I have this affidavit, my lord. There is a heart in this region, my lord. And that too by a private hospital, and there is a fracture, my lord. And my lord, plastic surgery was carried out, my lord. So, my lord, can I just pray? I'm not seeking today, my lord. I'm not seeking, my lord. If the diary doesn't come, my prayer for interim will be.
That will be considered.
Highly okay.
That will be-
Highly okay.
32.
All right.
Case diary not received, my lord.
Heard Mr. S. Nath, learned counsel for the accused. Counsel for the accused applicant also heard Mr. R.J. Borua, learned APE for the state. Then you write case diary in the instant case is not received. Interim order. Interim was not there. And later case diary come in this case. Let the matter be fixed on. Without the case diary, not possible in this case. Okay, on 12th.
3.
33 also, my lord, case diary not received.
Case diary not received. Case diary not received, let the matter be fixed on 13th one. No, I've seen the material. I mean, case diary will be
This is
required in
certificate.
this case.
It is part.
Hmm?
Part charge sheet.
Then, my lord, LCR may be called for, my lord, this year.
Part search there.
There cannot be part search then, my lord. This is a search sheet, my lord. There is no word like minor part search sheet, my lord.
I see.
The page number 19, my lord.
Hmm?
Page number 19, my lord.
So it was, I mean, it was not mentioned earlier. Why?
Your lordship, the first date I could not appear and examination was not.
Okay, this has come for the first time. But why then in hearing,
That is my.
it should have been in the motion? Mr. Borua, it should have been in the motion, this thing. Not in,
Earlier, my lord, already case diary, earlier, my lord, 16 matters were adjourned, my lord, subject to correction, my lord.
the 16 matter was adjourned for,
Adjourned.
only for this medical emergency. And there was no other date.
That is, my lord.
It should have been, listed in motion column.
Since the matter has come in the bail hearing column, my lord, see, may call for the TCR, man, of the con.
Okay, heard, Mr. Heard, Mr.
Yes, I just have.
Yes. Yes, tell me that, we don't have time, tell me.
Base 31.
Hmm.
Last year of the fraction.
Hmm.
Moreover, the prosecution sanction under Arms Act is pending.
Hmm.
On that basis of the sanction from the which is pending, this part supplementary charge sheet is being submitted.
So we'll see, we'll see, let it come. Heard Mr. So-and-so, learned counsel,
Yes.
like so-and-so and so-and-so, this is an application under, you write this. An FIR was lodged on 25/6/2025 by Havildar Chandrakanta Saikia to the effect that on 24/6/2025 approximately at approximately 8:20 PM an incident occurred at 11th APBN, Panbari camp, Bukakhat, wherein a grenade was allegedly thrown inside the campus by unidentified miscreants who came on a motorcycle from adjacent Panbari Road. It was alleged that the explosion resulted in injuries of 3 police personnel. Full stop. On 25, mixed para, on 25/9/2025, the investigating officer submitted a charge sheet before the learned subdivisional judicial magistrate Bukakhat, showing the name of eight accused persons, including the you are there. I mean, what is your name?
My name is Pataki. I am not even named in supplementary search, not in the FIR. And Lakhimpur police station, Lakhimpur OC. is
And right, and named eight persons. Full stop. The learned counsel appearing for the accused applicant submit that his name was not there in the charge sheet. Not there in the charge sheet. But however, how you are, I mean, you are apprehending now?
Paragraph number. Paragraph number 6. And paragraph number 6, actually I was not also present in the crime scene. Nothing has been recovered from me, but Lakhimpur police station, officer in charge of the Lakhimpur PS is constantly coming to my house. And the dates, your lordship, as per my petition, I have mentioned 5 December.
1 second, let me read. And what about last line, can you? However, on being suspicion, the police is visiting his place, and therefore he is apprehending arrest in the instant case. Full stop. The learned APP, Mr. R.J. Burwa, submits that since the charge sheet in the matter has already been filed, the same should be called for before considering the instant bail application. Full stop. The registry to call for the TCR in connection with PRC case number 78/2025 from the court of the subdivisional judicial magistrate Bukakan. Registry to call for scan copies, okay? Scan copies of forensic. Let the matter be fixed on. 11th will be fixing. 11th.
11 March.
No more dates are available, so 11th is the date.
they would take the CBI वाले जो दे रहे आसाम पुलिस का बहुत केसेस था ना कि पन्नों मजा का यही बात है कि हम CBI वाला किसका नंबर हो CBI वालों को बात कर रहा हूँ हाँ क्योंकि CBI वाला मैटर किया ना लेकिन CBI वाला केस का नंबर कितना सही था मैटर तो CBI का लेकिन वो तो ये तो पहले तो ये केस था ये तो शायद एक ही पलकन बाजार का था कि इतना केसेस था और तो तब तो वही है अब तो केस मिला क्या हो तब तो क्या वेरीफाई नहीं देखिए ये तो 47 शक्ति पता कोई बात नहीं सही किया care for the very human fellow. Having 6 years side by a law FIR against the petitioner not to show them renowned volleyball player lost to the organized volleyball on that night law. Now FIR is my lord at phase 9 law. Shall we see the legal scene of the my lord incident? Taking advantage my lord absence of anybody at home lordship at 10 p.m. lordship commission rep my lord to get rep by closing mouth by hand lordship.
Yes, Mr. Busho.
My lord, CD received, my lord. 183 statement is there, my lord. Oh, my lord, may kindly produce the same. Now, I have something lordship. My lord, stated the amount, my lord, closed by hand or committed rep upon me repeatedly. This is not possible but impossible. In my humble submission, lordship. On the other hand, lordship, I can see the my lord, some photographs, lordship. I have annexed, lordship, the screenshot of shot of the mobile, lordship. Live video at this 13, lordship. You are playing volleyball on that night, lordship. The tournament was going on throughout. Now, as far as calling, he was also there. My lord, as Kadisi at this 15, lordship, 27 January 2026, 8 p.m. lordship. My lord, 8 p.m. my lord, 8 p.m. he was my lord in the tournament lordship. LS incident of 10 p.m. lordship. That night lordship. At 2, next phase lordship, he was there lordship now at my lord, last phase lordship. 28 January 2026, 2 a.m. my lord, same night lordship. After 2 hours to 4 hours, he was there in the tournament. Before 2 hours, my lord, he was there in the tournament. But at 10, my lord, as he was, my lord, present the resident of the my lord, house of the my lord, informant lordship. This is my lord, absolutely my lord, malicious FIR lordship. My lord, he was my lord, that bit on the case my lord, by past experience. Actual fact, my lord, the family, my lord, is involved in my lord, head board, business affect currency business and many other my lord, and the social elements, activities lordship. He raised objections in as result. On the other hand, she have my lord, she had done my lord, child marriage lordship. Again, that also my lord, the petitioner my lord raised my lord, voice lordship. That is why my lord, to suppress him lordship, this affair was lost lordship. Well, throughout the night he was playing my lord, volleyball. He was the organizer lordship. My lord,
6 year child was there, lordship. What about the child? What about husband? What about the other family member? It is not stated in the FIR, lordship. 10 AM, lordship, 10 PM, lordship. At night, generally, my lord, all the my lord, family members remain at home, lordships. That too, after 6 days, the next incident was, lordship, on 27. Yeah, 27, 12, lordship, 27 January. Sorry, 27. Yes. And the FIR was launched after 2 days, 3 days, lordship. Yes, 5 days, lordships, without any explanation, lordship. She did not tell anything to any other family members, her husband. This is absolutely, my lord, false FIR, lordship. The FIR was launched on 3/2/2026. After 6 days, lordship. Without any explanation. Not if that she was a minor, lordship.
Investigation in the nascent stage. The rest, I'll leave it to your lordship. 183 statements and other witnesses.
Coupled with the, my lord, investigation of what extent was.
No, I mean, there are statements of witnesses, other witnesses also.
I know that.
Though may not be eyewitness, but there are witnesses that there was a hue and cry and they came,
Yes.
then they found out that that offense was already committed.
In case of the FIR, my lord, that's my lord, suggest to our lordship.
No, language of the
Here,
affair is clear.
It is clearly stated.
Language of the affair is clear.
In my humble summary, is it possible lawsuit? By closing mouth with hands.
Oh, that's how people rape. Otherwise, how they rape? Huh? Difficult at this stage. No, at this stage, it will be difficult. I mean, serious allegations.
Fine.
Serious allegations.
Why not, when question arises lawsuit, well, if he was my lord paying lawsuit, why he was not apprehended lawsuit? It is stated in the affair lawsuit. After 6 days, my lord lost the affair without any disclosure to her husband, my lord, going to be of the family lawsuit. About the child was with her also.
Child is a small child. Husband was in Arunachal Pradesh. Other people are sleeping in different places. Then who and cry? 6-year-old child. I mean, how? I mean, like, difficult at this stage. What, Mr. M.H. Ahmed?
He was playing game, my lord, he was, my lord,
But those documents you have submitted,
it's screenshot of the.
those are from different times. Time gap is quite long.
My lord,
8 p.m. and another one is 2 p.m.
Yes.
2 a.m.
what I'm submitting was.
2, 8 and 2. No, I mean, it will be, at this stage it will be
What I'm
difficult.
He had paid a real lawsuit. He could have been, my lord, apprehended, my lord, from the, my lord, ornament itself lawsuit for the night lawsuit.
No, on the night, FIR was not filed on the night. FIR was filed after 5
My
days.
lord, incident, after incident, my lord.
Husband was not there, or probably.
People came lawsuit, then he could have been apprehended by the people lawsuit. Why he was not apprehended?
Police is searching, my lord. In this regard, my lord, notice there, my lord. They are not finding him. His house is also, my lord, that is searched.
But he was there in the field.
My lord, at the point of time, my lord, that the FIR is lost, my lord, later.
The FIR was
And
filed.
183 statement, my lord, that part is clearly mentioned, my lord, because husband is outside, my lord.
No, that is correct. But
My-
thing is that, like, if hue and cry has been made, family persons came.
My lord,
I mean, she has 5 brother-in-laws.
my lord,
5 brother-in-laws have, deposed against
my,
the accused. But why 5 brothers did not go and like apprehended him from the field?
my. Lord, regarding that, my lord, that is the, my lord, cricket match or something, that part is not revealed in the CD, my lord.
No, but that is
That is not there.
there. But that is there in the the
yes,
same that he has given.
Petitioner story is there.
He has given this.
My lord, the non-explanation, my lord, delay, my lord, and the non-apprehension of the petitioner, my lord, he has doubt lawsuit, but the story was it in the, my lord, the affair law. He was here lawsuit. He got, got trophy also.
No, that's a different thing. He got trophy, he got gold medal, doesn't matter.
He was present here, law.
Doesn't matter.
I may see protect, I let here any condition may be closed lawsuit. I will compare to the lawsuit. It's an every case does not full lawsuit. Some false cases may also be, in my case, it may be false lawsuit.
The GD entry was made in 1-2 only. GD entry was made on 1-2. And an incident happened on 27th.
27.
27.
So did you? That was also by delay lawsuit. On to GLT, P2 my case was registered lawsuit. Was not apprehended.
Let him go, he'll cooperate. I mean, there are some,
My lord,
something is there.
my lord.
You heard, Mr. You are Mr. M.H. Ahmed, the learned counsel appearing for the accused applicant. Also heard Mr. K. Bosho, learned APP for the state. This is an application under so and so. And a FIR was lodged on 1-2.
My lord,
My lord, 1-2.
P2 registered.
No,
P2
one.
loss.
FIR was lodged on 3-2-2026.
There is 3-2-26. My vernacular can be seen.
But you have written 1-2.
And
Why do you make? this kind of mistakes. It is written in Assamese, it should be, it is not 3,
Like, or,
it is 1, 2 only.
so it is very awesome.
It is 1, 1. It is 1.
I'm sorry, but
FR was lodged on 1/2/2026 by the informant stroke victim, alleging that on the night of 27/1/2026 at about 10 p.m., the accused applicant, taking advantage of no one being there at home, entered her house and after tying her her hands, raped her, full stop. It was alleged that after hearing hue and cry, after the commission of the rape, hearing hue and cry, the nearby people came and the accused pled, threatening her with dire consequences if she discloses this the incident to someone, to anyone. On receipt of the FIR, the police registered Laluk PS case number 28/3026 under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicant was in fact not involved in the alleged incident of rape, as he was present on that date from 8 p.m. to 2 a.m. in a near where is this field? You have not mentioned where is this field?
statement loss.
Uh,
My lord, that's correct of page. 7 and 6, 7 and S.
he was in fact present in a volleyball tournament, namely volleyball tournament organized by the local youths of the village. He referred to certain screenshots of video of that volleyball tournament, wherein he is seen to be present. Full stop. He submits that it is not possible for him to go from the volleyball field and commit the offense and come back to the field again. He submits that there are certain enmities between the families of the accused applicant as well as families of the accused applicant and the families of the accused applicant and the informant. Full stop. He further submits that though the incident alleged to have happened on 27th that's 28 January 27-28 right midnight the FIR was filed only on 1/2/2026 without any explanation of delay. Full stop. He submits that the accused applicant is a renowned basketball player, a renowned volleyball player, and doesn't have any criminal antecedent. Full stop. And he is a young boy of 23 years old. He submits that he submits that taking into account the entire facts of the case and filing of the delayed filing of the FIR. And since the police has not arrested him till date, the accused applicant should be granted re-arrest bail at this stage. Full stop. The learned APP, Mr. K. Boysa, the learned APP, on the other hand, submits that there are many incriminating materials available in the case diary about the involvement of about the prima facie involvement of the accused applicant in the instant case. This court has gone through the case diary. Case diary full stop. It is seen that though there was an allegation that the rape was committed at about 10 o'clock, 10 o'clock at night, and on hearing the human cry of the informant, people gathered there. However, it could not be understood why the people did not go to the volleyball field where the accused applicant was present at that time and apprehended him. Full stop. It is also seen that the FIR was filed in a delayed manner without any explanation. Full stop. Full stop. On perusal of having found the aforesaid facts, this court should consider opinion that at this stage the accused applicant should be granted the protection of re-arrest bail. Accordingly, it is directed that if the accused applicant is arrested, then he shall be released on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authority in connection with Laluk PS case number 28/2026, subject to the following conditions. The accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Next, accused, then you put these conditions, and in terms of the aforesaid direction, this instant AB application is disposed of. CD to be returned. CD to be returned. So, Mr. Chaudhary.
Actually, my lord, my submission has been over. Government has to submit, and I shall get the reply of the government.
Government is not there.
Last time, they reply.
Last time also he was not there. No, he was there last time. We'll put it somewhere already then. Heard Mr. NNB Chaudhary, learned counsel, appearing for the petitioner. No, right, Mr. NNB Chaudhary is present for the petitioner. However, none present for the government respondents. Full stop. In view of the aforesaid, let the case be listed.
Last week or last second not available by.
On 25th of March. On 25th of March. Okay, 26th.
That would be my part. Now, here,
Was it part heard? It was not part heard.
Probably it is paid as part heard. I have completed my.
It was not part heard.
So here only the legal question is that court of session is a superior court to the special judge. The special judge is a subordinate court of session. And my case was that if a special court is a session court say it is not a subordinate court of session. Therefore, direction issued by the session judge to proceed with the trial itself is illegal. And by virtue of this illegality, the entire proceeding is illegal. Therefore, my submission is to set aside the order passed by the landed session judge, as well as the special judge bringing the order second time. And same matter back to the session judge to initiate from the stage of framing charge. Because what is the duty of the court at the time of filing charge sheet by the police? On that day, I please citation of that. I have behind the bar for last 350 days. And you for bail also, that was one of considered.
So you are challenging which order? Order of taking cognizance?
First order your lordship by page 18. Order of framing charge.
Yes.
Here the case was registered on the basis of FIR. Then I just for your page your lordship.
Yeah, can you please refresh a bit? I mean, I remember, I recollect something, but still,
Page 25 is the FIR.
page 25 is the FIR. Yes.
In the basis of page 25,
Hmm.
a case
Hmm.
under section 7665, where the POCSO was reached.
75,
76,
76,
65, 1,
76, 65, 1.
BNS,
Hmm.
read with 4 of POCSO,
4 POCSO, yes. It was registered on under this.
under.
Correct. Then
After completion, the matter was investigated.
after investigation,
Police at page 29, charge sheet, submitted charge sheet.
investigation, submitted charge sheet.
Police at page 29, this is the charge sheet and relevant part is 33.
Charge sheet at page
Charge sheet start from page 29
29.
and relevant part is 33.
Charge sheet was filed on when? FIR was filed on?
FIR was on,
FIR is page 25.
yeah,
FIR was on 11/3.
25.
11/3/2025. Charge sheet was filed on page 29
Page 29,
on 8/5.
85.
Charge sheet on 8 52025, yes. Yeah, in charge sheet, what are the sections? 70,
Page 33. Review portion.
page 33. Page 33,
What?
yes, 76,
76, 65, 1.
65, 1. But initially FIR was on something else.
75, 64, 1.
The FIR was under 76, 65, 1 and 4.
Oh, and charge sheet is under 75, 2,
No, charge sheet is under
75, 2,
75 to
64, 1.
1 second,
Yes,
75 to
64, 1.
64, 1
BN.
BNist.
No POX.
So POXO is gone.
POXO.
POXO gone.
Therefore,
Now after this, what happened?
but the case was,
Hmm.
since initially registered under POXO,
Hmm.
the charge sheet was placed before the special. Case 43 order.
1 second. The CS was filed before the POXO court.
Yes, because case was initially registered.
Correct,
as
correct,
POXO.
correct. Then what happened?
It was placed before the special court,
Special court POXO, yes.
43 page.
43. 43.
Last paragraph will be.
Okay, page 43.
As the charge sheet has not been filed,
Hmm.
under last paragraph.
Provisions of POXO and the original case record containing GR case number so and so
Yes,
be forwarded to learned CGM.
that is in view of section 2, now 251.
6.
Earlier it was 220.
Hmm.
Because. So he has
Under which section?
251. 251. Because 251 say,
Hmm.
if no offense is made out,
Hmm.
session court is to transfer it to C.
CGM. So accordingly, I mean, POXO court has sent it back to CGM.
CGI.
Back to CGM, yes.
Now CGM after receiving, it is,
Hmm.
he has forwarded it again to the session judge,
Which order?
page 20. And the session judge upon receipt,
Session just page 20.
page 20. By this order,
Okay, this page 20 order.
passed by session judge.
No, CGM order, CGM order.
CGM order, I have not.
You have not annexed.
That he
CGM
recommends-
transferred to session judge, then
Session judge.
on 26/6.
Session judge by its order dated 26/6/25.
Guys. So what session judge did? Session judge?
Your lordship will
Hmm,
skip past.
now,
Paragraph beginning page 21.
so IO has not collected so and so, accordingly transmit the case.
Hmm.
IO of the case has not collected as
Page 21.
and he has done so much of this victim seeking permission on the court.
Accordingly, case record of the instant case along with the case diary. and the
One second, send back to POXO again.
POXO again.
POXO again stating that age verification was not done as per law.
And thereafter, by page 18 order, he has framed charge and proceeded with trial.
After this, by this order, which order?
Page 18.
Page 18. Page 18,
The POXO court has framed charge.
1 second. Page 26/6. Page, page 20. Then. Yes.
that this is the case. And
So your contention is that,
thereafter, he has proceeded in the trial now taking evidence, etc. Matter is at evidence
method is at evidence stage.
list.
So no one has appeared as yet.
4, 5 witnesses so far examined.
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 Method is evidence stage.
Now, I was arrested on 16/3/2025. And since then, 338 days.
Arrested on
16/3/2025.
16/3/2025.
11/3 FIR, 16/3 arrest.
Okay, when this was, okay. So you were arrested
Before filing.
before filing of the charge sheet. Okay, now this trial has proceeded.
Now the entire argument is.
So, I mean, now thing is that you have come in a delayed stage, but since it's a legal legal point is involved, you are challenging this.
Initially, I filed a bail application.
No, but like you didn't challenge this order earlier.
That order within limited period of limitation I have challenged.
Which one?
Within 90 days I have challenged. Now, because date after date it is delayed.
So, yeah, I mean, within 90 days, you have filed it on when?
Yes. 90 days. Because in the revision there is no delay.
So you have filed, I mean, revision against this order
On
within
4/11.
time, 4/11. Okay, correct. Yes. Carry on, then.
Now my first argument is
Hmm.
the special code is constituted under section 28 of PROCEEDINGS.
Hmm.
The language of section 28 is very clear
Hmm.
and specific.
Hmm.
That only a session judge, though session judge includes additional session judge, only a judge of the rank of session
Correct.
is entitled to appoint as POCSO special.
Hmm.
That means a POCSO, special judge POCSO itself is a court of session. That has been categorically mentioned under section 31 of POCSO.
Yes.
Now 31 says
31 of?
POCSO
Yes.
that save as otherwise provided in this provision of Code of Criminal Procedure, now PNS, shall apply in the proceeding before a special court, and for the purpose of the said provisions, the special court shall be deemed to be a court of session. So a special court is a session court.
But it has to be designated, right?
Designated notification is there, one of the notification.
When a designated means like a particular court. I mean, there may be, if there are 3 additional session
Yes,
judges,
one has to be
then one has to be designated.
designated, terms of 28,
Correct.
in terms of section 20.
One has to be designated.
The designation will be made by the state government
State government.
and upon consultation with the Honorable Chief Justice of
So that designation will be there, and in your case, the designation is already there.
Yeah.
Already there. So your basic
the
contains.
session code,
Hmm.
the special code is the session.
Hmm.
And section 251. Earlier 221.
Hmm.
It says, yes,
Section
51.
251 of BNSS. Hmm.
If after consideration of hearing as aforesaid, the judge is of the opinion that there is a ground for presuming that the accused has committed an offence
Hmm.
which is not exclusively tried by the court of session, he may frame charge against the accused and by order transfer the case to the trial to the chief judicial magistrate or any other judicial magistrate of the first class and direct the accused to appear before the chief judicial magistrate or the judicial magistrate of the first class. So, up to there, I have led to your lofty order, page 43 order, that the first instance, the special court has done correctly. He has since found that it is not charge sheeted under POCSO.
he has transferred in lieu of prohibition.
So your contention is that like, then your contention is that
Now,
now the CJM, he has referred it back to the Sessions Court.
session. Now, what was
And
the
Session Court found that there are certain, I mean, as far as the age verification is concerned, the police, without taking the court's permission, age verification has been done, and which is not correct. So he transferred the matter again to POCSO
direction?
with a
Not
direction.
that transfer, direction
Hmm.
to carry on, to proceed with the trial.
Correct,
And accordingly, page 20 order is.
passed by the POCSO court.
So my submission is, my entire case is that the session court, since not superior court, the order passed by the directing special court to proceed with the trial is vitiated under. And because the order is illegal, because he has transgressed the jurisdictional fee,
Hmm.
and therefore the whole proceeding thereafter is vitiated. Now, I have on the other day, once again, I got before, collecting your lordship, my body on one that submission. Here, the Supreme Court has specifically given 4 options. Yes, police, I am not saying that police is correct in not adding section 4. Police will be wrong. Now, there is why all these books are necessary. If everything is as per whim is doing, then nothing will be necessary.
No, I understood your case. I understood your case. I mean,
Submission is there. The moment session judge has found that the investigation is error, there is error in investigation, or police is not correcting, not submitting charges under section 4 of POCSO. Now, what was his duty as held by the Honorable Apex Court? 4 options. He can do either of the 4. He did nothing. He ignored the ratio laid down by the Supreme Court. And he.
and even, and in that connection, you have given this case, no? This,
Case number 2.
now this, which court, which case was given? I mean,
State Cross Central Bureau of Investigation.
that one.
Here, my relevant paragraph is 43, 49.
No, 1 second, 1 second. Where is that case? Yes. Para 43 and 49.
49, and that also supports 77, 86, and 86.
86,
77, 86, 87.
76, 80,
6 and 86.
86, 87.
Primarily
Primarily 43.
43. 43 said mistake.
Hmm?
If it appears to the court that there is a mistake,
Hmm.
then court to order for further investigation. And 49 says given the 4 options.
Hmm. 49, the 4 options, accept the report.
Either accept the report, second reject the report, and proceeding to be as a complaint case, he can take the proceeding in asking the informant to come and give evidence.
But this should have been done by the POCSO court.
No,
Which court?
because POCSO now no.
The
POCSO-
section is not there.
Not there. It because since 75 is there, ref section is there. So it is now automatically it is a trial court, session court is a trial court.
Hmm.
Because case is charged under 76. I have not totally given final report that 76 is there. That is offense of prohibition.
76 is session tribal, so I
Yeah.
mean, it should have gone back to
Gone to
session
session.
court. Session court should have,
Got
session court should have ideally taken one of the options.
one of them.
One of the options, but that hasn't been done. It has again directed the POCSO court to frame a charge
Therefore, on the order is
without any investigation.
out to be under law.
Okay, I got your arguments. I mean, that's all right.
Yes.
Yes, Mr. Borua.
And my submission is that since it is illegal, the entire proceeding is over. So session court should, from that option, man, from the point of presentation of charge sheet, he can do any of the 4. From that point, he should start. And in the meantime, I will be allowed to go on bail because only the 314
behind that.
The question is that, my lord, this is a criminal division petition, my lord, wherein, my lord, he has challenged the order of the, my lord, learned session judge, my lord. The fact of the case is that, my lord, FR was lodged, my lord, wherein section 4 of the POCSO, POCSO was added, my lord. Then during, my lord, submission of the charge sheet, my lord, IO says, my lord, what
No,
IO says,
that I
that
understand.
lordship has already gone through. my lord. IO
Ossification
says, my
test
lord,
was done.
the test was done, and, my lord, seems that, my lord, she is above 18 years, my lord.
Ossification
Over
test
18
was done and like,
POCSO was not added, my lord. Accordingly, my lord, this
just placed
also,
before
my
the.
lord, it should not be sent to the POCSO, but it was sent to the POCSO court, my lord.
Hmm.
The POCSO court found that, my lord, that since there is no, my lord, charge sheet under section 4 of the POCSO Act,
Send it
so
back
he
to
demanded
CJN.
back to the, he sent back the case record to the learned court of Chief Judicial Magistrate, my lord. Now, Chief Judicial Magistrate, having found that it is a case of, my lord, rape, my lord, so it was again forwarded to the Honorable Court of Session Judge, my lord. Learned Court of Session Judge, my lord. Now, my lord, what the order dated 26/6/2025 says, my lord. I am not reading everything, my lord.
So he is
Page number 20.
arguing only on the legal point. I
Legal
mean,
point, my lord. Yes, my lord.
that-
Lordship, may I kindly come to, my lord, page number 20, my lord.
page number
Chapter
20, yes.
Paragraph number 6, my lord.
Hmm.
In the charge sheet, the IO mentioned that though the case was registered under section 76/65(1) of BNS, read with section 4 of POCSO Act, based on the Azahar, but the age determination test reveals that the age of the victim likely to be more than 18 years, hence IO submitted charge sheet against the accused Asadul Islam under section 75 to 64(1) of BNS. The IO of the case has not collected any high school certificate or birth certificate or any other age proof certificate of the victim girl, and he has done suo moto age determination test of the victim without seeking permission from the court. But this is very important, my lord. So IO, my lord, while finding the charge sheet, my lord, without taking
No,
any
that is,
permission
all
from
these things are understood. That is, he is admitting this. There
My-
is no problem with
So
this.
what is the wrong in this order, my lord? That my learned friend will have to, my lord, point out, my lord.
No, he's pointing out now that, I mean, that legal issue, that being POCSO court itself,
My lord,
being an independent court designated.
my lord.
So it is not, I mean, he cannot be directed by session court to frame charge directly without having any other investigation.
No, my lord, that has not been done in this case, my lord.
Why?
In this case, my lord, in charges was submitted, my lord, in POCSO court. POCSO court found that, my lord, since there is no charge against, my lord, no charge under section 4 of the POCSO Act, it was sent to the judicial magistrate. Now, judicial magistrate having
No,
found.
without having further investigation, whether the session court could have directed POCSO court to frame charge against, this thing,
My lord, that, my lord,
against POCSO Act.
Section 251 is clear, my lord.
Which one?
Section 250 are framing of charge, my lord, earlier 228, my lord, CRPC.
No, whether he can direct to the other court, POCSO court. Or
No,
POCSO court,
yes.
when a POCSO court, in fact, a POCSO court could have done it of his own.
My lord.
If you would have come to an conclusion that there was insufficiency of materials or insufficiency of the investigation, then further investigation could have been done.
My lord, jurisdiction of the session court and the POCSO court is the same, my lord.
Hmm.
Only for the offences that has to be, my lord, tried by the, my lord, special court, that has been designated as a POCSO case, my lord,
Correct.
POCSO court, my lord. Otherwise, my lord, the
That is
jurisdiction of,
the argument only.
yes, jurisdiction of the POCSO court and session court are same, my lord. Now, my lord, what in this case, my
No,
lord,
that is his the precise argument. He's saying that how session court can transmit direct a court of similar jurisdiction.
The question is that, my lord, POCSO case has to be tried by a POCSO court only, my lord.
Correct.
It cannot be tried,
He
although,
can-
my lord,
I mean,
the
he-
jurisdiction are same,
he-
my lord.
No, there is no wrong by the, it would not have been any wrong if the session court would have simply transferred the case to the POCSO court. But he has passed an order
My lord.
saying that he frame charges under POCSO, POCSO Act. Without having any material, because police has already submitted the charge sheet, and charge sheet there is no POCSO.
I said this is not POCSO, my lord. Why it is not no POCSO?
No,
my lord?
correct. That's why, no, without further investigation, police has already given a charge sheet, right? Submitted a charge sheet, wherein it has, the POCSO is not there.
My lord.
Now, without any further investigation and without analyzing the materials beforehand, before the court, how can it give the, on his own, he can frame charge without hearing the parties also?
No, my lord, before charge, my lord, it is nowhere says, my lord, that that the parties were not hurt, my lord. Because at the time of framing charge, my lord, the accused as well as the, my lord, the public prosecutor has to be heard, my lord. And lordship may kindly see the other paragraphs, my lord. My lord, paragraph 9 on 1, my lord. The ossification test or any other medical age determination test conducted is not conclusive or determining the age of the victim. The court has to go through other aspect also for determining the age. Accordingly, transmit the case record to the instant case along with the case diary and the bail petition number so and so to the court of learned special additional session judge come special judge Pokso Lakhimpur, not Lakhimpur, after registering of a case, registering of the case as a Pokso case, my lord.
Correct. So these
So
are
only directed to register a case, my lord. It is not directed, my lord, the charge should be framed, my lord.
The next paragraph to Prohibitions.
Then, my lord, the learned additional session judge come special judge Pokso Lakhimpur, not Lakhimpur, will determine the age of the victim as per provision of law, my lord. And will proceed with the case accordingly, my lord. Where is the direction, my lord, that you register, use frame charge under section 4 of the Pokso, my lord?
Then how he has ordered, he has reviewed his own order. Then I will argue on that line.
No, one second.
This special court has reviewed its own order. Earlier he has
It
transferred.
is why, my lord, I have pointed out, my lord, there is no illegality in this order, my lord.
Then tomorrow, my lord, Madras High Court will issue direction to the Gauhati High Court, and Gauhati High Court will issue
No,
direction to the.
Madras High Court,
Special background.
Madras High Court direction to Guwahati High Court, that cannot be, my lord.
Yeah, that is.
No, 1 second, Mr. Woodard, no, sir. Yes.
So, my lord, that is why, my lord, I have, from the very beginning, my lord, I am pointing out, my lord, only this aspect of the matter, my lord. My lord, to set aside an order, my lord, there has to be some illegality, my lord, committed by an trial court, my lord. Or error apparent on the face of the record, my lord. Only on to these circumstances, my lord, a order, my lord, can be quashed, my lord, or set aside, my lord.
Okay. Anything else?
So this is my humble submission, my lord.
Hmm.
Because there is no
So,
direction, my lord, as such.
so your submission is basically that since session court cannot adjudicate the matter,
My lord,
it was sent back to the additional session judge, who is the designated POCSO court,
my lord.
to frame, no, not to frame the
Not frame
charges,
charge, my lord.
to register a case under the POCSO
So, my lord.
and determine the age
Determine
and
the
proceed
age.
accordingly.
This para 11 is very important. Standard additional session judge come POCSO court, my lord. Lord Lakhimpur will determine the age of the victim as per provision of law and will proceed with the case accordingly, my lord.
Okay.
And my learned friend, my lord, she is appearing for the informant, my lord.
Yes.
She will make her submission.
Yes.
My lordship, on last occasion when the matter came up, my lordship had asked me whether any ruling or something I could find
Yes.
in that regard.
Mm.
But to be very honest, I tried my best and I could find only 2 things, though there is no specific.
Mm.
But one of the cases is of my lordship would like to take a order of the single judge.
Mm.
My lordship would like to take an order of the single judge.
Obviously, why not?
Yes. Allahabad. Right. My lordship, here, before proceeding to the single judge, my lordship, there is
No, he has pointed out what is, I mean,
Yeah.
already.
in
uh,
the 2014, 2013 Supreme SC 1070, my lordship. This is
You have given me 2 cases.
2 cases, 2 different, one of single judge, one of Supreme Court. Yes.
One you have given me from the Supreme Court. Yes,
Yes.
you want to refer to Supreme Court
Supreme
one?
Court, I would go to paragraph number 14 and 19.
Para?
14 and 19.
Yes.
14 and 19. Here is the question, my lord.
One second. Para 14 and 19, yes.
14. May I read, my lordship?
Yes.
14. The question therefore emerges as to whether the complainant, informant, prosecution would be precluded from seeking a remedy.
One second, one second, one second.
It's page 10, my lordship, for 13. Page number.
You wanted to place the Supreme Court case, right?
Yes, my lordship.
Supreme Court of India, I mean, this Dinesh Tiwari.
Yes, my state of no matter state of Gujarat versus Girish Radhakrishna Varde.
You have not given me the case. How do you prepare your cases, madam?
No, my lordship is. She really took phone. My lordship got state of Gujarat versus Greece.
This is Dinesh Tiwari again.
Actually, my lordship, I'm giving my judgment.
Here, para 14 and 19.
14 and 19. 14 and 19.
Yes.
And then in the other one, my lordship,
14 what, also you don't have the case.
14 and 19. Actually. I'll do lead one.
So what is your argument on the basis
Uh,
of this case?
On this basis of this case was that, on the basis is that at the time of framing of charge, at the time of framing of charge, when both sides are heard, at that point of time, they can raise the issue. So here in this case, my lordship, what happened was that here in this case, with regard to this judgment, Your Honor, that the Supreme Court has clearly stated that at the time of framing of charge, even before judgment also, if the court finds that there is something apparent, it can forward the same. So here my submission is that with regard to the present impugned case is that since this case was forwarded before the Honorable Sessions Court to frame the charge, and at that time after hearing the points, as the age determination question came, as such it was rightly forwarded to the special court. Special court to determine the age and thereafter to proceed accordingly. And thereafter the learned special court rightly has framed the charge and thereafter proceeded with the trial in which 4 to 5 PWs are already examined.
And
and the single judge matter, my lordship, here what happened?
Single judge is
Yes,
from,
is state of Ashish Kumar and
this is Allahabad.
Allahabad. Yes, Allahabad High Court.
But you didn't say Allahabad, you said
Yes.
single judge.
Allahabad High Court.
We presume that it is from Gauhati High Court only.
No, my lordship.
But anyways, which para?
I'll go directly to page number 9 of page 8 of 9, para 13. Here is a case in which the IPC sections were added and the POCSO was left behind. And in which what happened was that the learned court has returned the charge sheet. So the learned apex court has, by citing the citation of the apex court, the learned court has stated that In a case which is triable by court of session, though the magistrate cannot add or alter a charge, but he is empowered under section 209 and 323 of CRPC to commit the case to the court of session. And in case of a POCSO court, it can directly proceed to a special court also.
Para 13.
13. 13 and the final at 14. Here,
No.
here the the learned court has discussed, the Euro committee in the Allahabad High Court judgment was that by the trial court was that they have returned the charge sheet. Returned the charge sheet. But in our case, the charge sheet was not returned. It was forwarded to the Sessions Court. And thereafter, the Sessions Court has rightly, to determine the age since cannot be done by the Session Court, has forwarded it before the Special Court to determine the age. And it says, this judgment clearly says that the magistrate has power, ample power to, under section 209 or 323 of the court, to transfer the case, to proceed the case, even to the Sessions Court and even to the Special Court also.
No, the question remained that, I mean, there were charge sheet, okay, charge sheet was filed. And in the charge sheet, there was no element of
Yes.
POCSO Act,
Yeah.
right? Now, it has been sent to the Sessions Court. Now, Sessions Court, since there is nothing in the, nothing of POCSO is involved there, but he took a decision that the case should be transferred to the POCSO and registered.
Yes.
Register a POCSO case. So without having any material of bringing in POCSO Act,
Yes.
whether it could have been sent back to the POCSO court or not. That is his contention.
Yes. And with regard to that, on last occasion, directly to that specific point, I tried my best. I couldn't find any citation or addition, but to the extent that when prosecution is prejudiced, that cannot be done. So these points I could find out. Exactly. Specifically. with
Because
regard to-
before the Session Court also, there was no material available for, of POCSO. Because charge sheet was not under POCSO.
Yeah.
So without having any material, whether the Session Court has the jurisdiction to direct the POCSO court to register a case and thereafter you do the investigation, whether he can do
determine
it. That is your question.
This is one point I was
Mm, mm.
like BP has, I have not challenged the order of session. The logic page 15 of my.
Page 15.
This is my.
Yes.
Under the premises aforesaid, it is therefore prayed that your lordship would be pleased to admit this petition, call for the record and issue rule calling upon the opposite parties to show cause as to why in order dated 11/8/25 passed by landed disputation as POCSO Lakhimpur in such and such framing charge against the petitioner under such and such and order dated 26/6/25 passed by landed session judge in session such and such, where shall not be set aside as to why the landed discussions as POCSO Lakhimpur.
Yes, I got it.
So this, I have categorically challenged this order. And my friend has, landed PP has, I think, is just a mere direction to determine the, no. And Lakhimpur is what? And.
No, we have indicated that, that the direction was to register a case under POCSO.
And proceed accordingly. And in view of this order, the special court has reviewed its order, because criminal court cannot review its order. Earlier he held that this is not the case, he transferred it.
The charges can be framed later on also. Charges
This is
can
my
be,
submission.
framed later on also if there is a material due,
That can be ordered.
anytime before the judgment.
Yes, this can be ordered.
It can be altered, it
But
can-
procedure has to be good.
it can be added.
Yeah. Alteration, addition, everything is there, but with a certain procedure.
Yona, I have one submission to make.
Mm.
Yona has asked me one thing that how the session judge has determined it has passed to the POCSO court only on the basis of the search sheet. In the search sheet, it reflected, I'd like to take, in the search sheet, it is clearly reflected that the IO has written a note in which it has stated that though the case is registered under section dash dash of BNS read with section 4 of POCSO Act based on FIR, but as the age determination test reveals that the age of the victim likely to be more than
No,
18,
that's
so,
no,
so on the basis available, so I will come to the, my submission to this extent is that since the matter went to the sessions court, so I'll consider that this was a stage in which the charge was decided and both the counsels were heard. So on that, on the
And the session court did not hear anybody.
no, Your Honor, it was before the sessions court. Your
And
Honor,
the session court did not heard anybody, did not hear anybody.
Your Honor, there is the order. Accused is physically produced before the court. He is represented by his engaged counsel desk. The heard learned counsel desk appearing for the accused and MP Hazarika learned additional P appearing for the state. On perusal of the records of the case, it appears. So, Your Honor, it could be taken.
So that is the order he has challenged.
No, my submission is that.
No, we have
That clear
concluded.
that on this, the charge was heard on that day, on the point of charge. So on that point of charge, when it is heard, the sessions court on the available.
Point of charge.
On the bail application, because it is a continuation application. Because
It was not, I mean, it was not a charge hearing.
bail application, but it was a continuous order.
It was available before the filing, can take the case record of the POCSO court to enter a case, was that the certain matter, wherein the IO captured.
No, her submission is that charge sheet has certain materials.
Yes.
And on the basis of the materials, session court came to a conclusion that this is a POCSO tribal case and the investigation was not done properly, age verification was not done properly. So it should be, it should be sent back to the POCSO court. And POCSO court, but only thing is that like direction has been given to register it. Register a case under POCSO and thereafter do the investigations. That was.
Yes.
Thereafter, in accordance with the by closure of duty. It is observed of the learned.
Okay, heard Mr. AI within the learned counsel appearing for the petitioner. You then Mr. R.J. Borwa, learned APP, and MS Borwa,
S.J. Borwa.
S.J. Borwa, learned counsel for the informant. Hearing concluded, judgment reserved. Hmm?
Your Honor, one more submission with regard to the bail, since it's a revision petition, in a revision petition bail, for a bail separate organized.
Number 36 for orders.
Okay, heard Mr. So and so. Your name, please? Udas, the learned counsel for the petitioner. Your
I'm GRA Muttaki.
so and so for the respondent. TCR in the instant case is yet to be received. Issued reminder for the TCR of CR case number 245 of 2025 from the court of the learned JMFC Kamrup Metro Gauhati. Let the matter be fixed on 25th of March. 25th of March.
May I submit one thing, Lordship? My instruction is that both the parties are living peacefully. As of now, both the parties are living peacefully.
No, that is, I mean, that will be considered.
Alright.
With the case then. What is your this thing? Do you have any instructions? He doesn't have any. If you have some instructions, let the court know on the next date.
37.
Wait. Service report is still awaited. You have taken steps when? Office note reveals service report on respondent service report of service of notice on respondent number 2 is yet to be received. So we'll wait for some time. Let the matter be fixed on 19 March. 19 March. Mr. Chaudhary, you have some matter?
Yes.
Which one?
This one.
51.
Lord, an application was filed for discharge.
Who is for the other side?
CBI.
CBI is not there.
Permits, I can start, it will take some time. They can reply on some other list. I can start, I'll not take very long. I think they will,
But without them, should I? CBI, anybody is there? CBI? Hmm. Phone number is anything.
Look, I can just start, Miller.
Okay.
Can you see? Miller, please come to the complaint at page 36.
Mr. Borua, if that CBI counsel is there, please. Yes.
Look, the petitioner before Lordship is a commissioner of income tax, Miller. He is an IRS officer. Kindly see, Miller, how mechanically things have been done. This is 14th of September 22. With due respect, it is submitted.
Where are you reading, Mr. Chaudhary?
Page 36.
Page 36, yes. Yes, yes.
The Superintendent of Police, CBI. With due respect, it is submitted that I am proprietor of Pawan Enterprise, S4. The Pawan Enterprise is a registered contractor under NF Railway and Assam Power Distribution Company Limited. Further, in connection with the construction work related to NF Railway Maligaon was done by Pawan Enterprises. After that, bills related to the said work were submitted by me before the Deputy Chief Electrical Engineer NF Railway. The Additional Commissioner Central Goods and Services Tax Executive raised the demand of service tax amounting to rupees 48 lakhs 23,000 and on, while later it is so. In this regard, I wish to submit that no service tax was required to be paid for those works, as the same is exempted by Government of India. The concerned office of the NF Railway also issued a certificate that those original work done by the Pawan Enterprise is exempted from making payment of the service tax. Agreed with the order of the Additional Commissioner, Central Goods and Service Tax. Service tax. I preferred an appeal before the Commissioner Appeal CGST, Central Excise and Customs Gauhati against adjudication order dated 23/7/21 on 19/10/21. Hearing on my appeal took place before Sri Raju Saktivel, Commissioner of Appeals, on 5/5/22. However, I am yet to get an order on my appeal. In the month of August 22, one Sri Rajendra, who was also present at the time of hearing of appeal, telephonically informed that Commissioner Sri Raju Saktivel wished to meet me in the above pending matter. Accordingly, I met Raju Saktivel in his chamber on 3rd floor, CGST building, Gedda Road, Maswa, Gauhati, on 24/8/22. During meeting, Sri Raju Saktivel introduced me with Sri Rajendra, who was present there, and assured me that favorable order would be passed if I would pay 4,50,000. I submitted to Raju Saktivel that I have merit in my appeal. He told me that I am required to pay 4,50,000, that is 10% of the demand of the tax amount. He further instructed me to pay the amount to the said Sri Rajendra for giving favorable order. I did not make any commitment in the matter. On 8/9/22, Rajendra approached me for payment of rupees so and so. I am unwilling to pay them any price. It is therefore requested that necessary legal action in the matter may be taken. Lord, it's a very clear, simple case, Miller. According to the complainant, he is a contractor under NFA, and he did some construction work which according to him is exempted from payment of GST. Therefore, according to him, the demand was unlawful. Nevertheless, Miller, there was an adjudication ordered by the GST authority. Against that, he preferred an appeal. And the appeal was listed before the present petition. And according to the complaint, Miller, in the month of the kindly similar, according to the complaint, on 5/5/22, the appeal was heard.
Yes.
Then in August 22, on 24/8/22, the complainant met the petitioner at his office in Gauhati, wherein a demand of 4,50,000 was made. Am I clear, Miller?
Yes.
This is the allegation. Now, Miller will kindly come to the next page. That's the report of the superintendent of police of CBI. In this 2-page, Miller, the case hinges. A letter of complaint dated 14/9/22 has been received from what? Page 39.
Yes, yes.
A letter of complaint dated 14/9/22 has been received from one Sri Sitaramdar Nath, late Indra Prasad Nath, resident of so and proprietor of Pawan Enterprise Tezpur, wherein it is alleged that the proprietor of Pawan Enterprise Tezpur executed construction work related to NF Railway and raised bill. The additional commissioner of Central Goods and Service Tax, Dibrugarh, raised a demand of service amounting to 48 lakhs and not, while later it is so agreed with the order of the additional commissioner. The complainant referred an appeal on 19/10/21 before the commissioner against the adjudication order dated 23/7/1. Hearing of the said appeal took place before Rajesh Shaktivel, commissioner, on 5/5/22. However, no order has yet been passed. Instead, he demanded 4,50,000. That means, my lord, the demand was made on 5/5/22 according to the superintendent of police. But therefore, I am saying, my lord, my entire case hinges on these 2 pages. According to the complaint, the complainant met the petitioner on 24/8/22 when alleged demand was made to Rajendra. And according to the verification report of the superintendent of police, the demand was made on 5/5/22. Now, my humble submission is very simple. On 5/5/22, let me steer clear of one fact that by state, Miller. If your lordship would kindly come to page 253, D37. This is the Miller, so-called what we call Hadira in our language, Miller.
253.
253.
Yes.
Now kindly see, the authorized representative has appeared before me and submitted his written as well as oral representation and requested for
Adjournment. What? Appropriate
Appropriate
relief. Appropriate relief.
relief.
Appropriate relief.
So I am reading it again, Miller. The authorized representative, that means the complainant was not present on that day.
And it was
Mahavir Prasad Bagaria was there. Authorized representative of the complainant has appeared before me and submitted his written as well as oral representation and requested for appropriate relief. 5/5/22.
so there was no hearing on the date.
Maybe there was a hearing,
Hmm.
but the appellant was, the petitioner was not present.
Petitioner was not there.
So to make the demand.
Hmm.
So this is, so that's why I said, Miller, I must steer clear of the controversy, whether on 5th I was there or not. Now, according to the verification report of the Superintendent of Police of CBI Miller, and the hearing took place on 5/5/22 when the demand was made. Miller, in fact, after 5/5/22, there was no hearing took place. End of the day, Miller, it's a question of framing charge. Mere suspicion will not do. There has to be a grave suspicion. If there is only a suspicion, then he is entitled to Miller to be the charge. Now, Miller, going by the complaint, that on 24/8, though Miller, no date was fixed after 24/8/22, 5/5/22, the allegation is that the complainant met the petitioner on 24/8/22 at his office when he demanded 10% of the assessment value. This is sheer false and utterly, Miller, cannot be believed for the simple reason. In such an instance, Miller, his attendance should be there. Let the CBI authority show from the whatever investigation they have done, that either in the form of a CC camera footage or in the form of some proceedings. And normally, Miller, in a proceeding, normally it will be there. If somebody attends a hearing, then attendance will be there. Visitors list could be there. So, prima facie, Miller, there is no material. And no witness has corroborated this, Miller, that on 24/8/22, the complainant met the petitioner when the alleged demand was made.
But Mr. Chaudhary, I mean, this information, that part you have read, whether it makes out in a case that like on the date on 5th only it was demanded.
Yes, Miller. Can
How-
you see? Yes.
It says,
Hearing of the said appeal took place before Raju Saktivel on 5/5/22. However, no order has been passed.
no order has yet been passed.
Instead, he demanded.
So it can be on a later stage also.
He was referring to a date.
No, he's
Assuming that is there, Miller, assuming that was there, then when did I meet him on 24? On 24/8, what is the material, what is the corroborative evidence material?
that has to be looked into. That has to be looked into. That
Miller, my understanding, subject to what your lordship may say, I'm reading it once again, page 39.
yes.
Hearing of the said appeal took place before Rasul Saktivel on 5/5/22.
Yes.
However, no order has yet been passed. Instead, the demanded so. Lord, end of the day, when you are trying to fasten me with a criminal liability, your allegation has to be specific. If there is a scope of any, Miller, interpretation or scope of leeway, then, Miller, the prosecution must fail. At the end of the day, it's a very serious matter, Miller.
Absolutely.
Now, the context in which the statement has been made, Miller, it has to be correlated with 5/5/22. Had it been a later date, then Miller, they would have clearly said. Miller, most importantly, on 5th.
You are not there.
I'm not. No, I was there, Miller. I was there. The complainant was
Complainant
not there.
was not there.
Because his authorized representative, Mahadev,
That is clear.
Okay.
That is clear from this. I
Yes.
mean,
Yes. Now, please come to page 36. The complaint. In fact, my lord, after 5/5/22,
yes.
no date of hearing was fixed. In the last para, in the month of August 22, one Rajendra, who was also Rajendra to take him, A4, yes. Rajendra is A4,
Okay.
yes. In the month of August 22, one Rajendra, who was also present at the time of hearing of the appeal, telephonically informed that the Commissioner Sri Raju Saktivel wished to meet me in above pending matter. Accordingly, I met Raju Saktivel in his office chamber on the third floor of the GST building on 24 April. During the meeting, Raju Saktivel introduced me with said Sri Rajendra, was present there and assured me that favorable order would be passed if I pay 4,55,000. I submitted to Raju Saktivel that I have managed with my appeal, etc., etc. So, my lord, going by the complaint, the allegation is that on 24/8/22, the complainant met the petitioner, who was the Commissioner of Appeal. At that point of time, A4 was also present.
Yes.
Purportedly, on that date, he made a deal. First come, first, my lord. Tomorrow at the trial, the prosecution will have to establish that on 24/8/22, complainant was present and met the petition. There must be some evidence must be laid. Which evidence, my lord? Is there any CCTV footage of your office? Is there any entry list of visitors? Office? Something, my lord.
Yeah, something has to be there. I mean, if there is an allegation, then something has to be there.
Also corroborated the same version. Now, Lordship knows, but my lord will kindly see now. Here the subheading of my argument would be, kindly see the date of the complaint, my lord.
14.
14/9/22.
Yes.
And when the alleged incident of demand was made, 14/8/22. Why 1 month, my lord? If it's so serious, if it's so conscious, self-conscientious citizen, why he did not report the very next day, or maybe day after, 2 days later?
So delay of complaint, basically.
Delay,
Delay of complaint, not explained.
not ex-
Yes.
Now, my lord, the second limb of my argument in this regard is the verification report of the superintendent of police does not support the allegation in the complaint. On the contrary, the SP's verification report showed that the demand was made on 5th. When admittedly the complainant was not present.
Yes.
These are serious discrepancies, below.
Yes.
So now, Lord, other two aspects would be after hearing on 5/5/22, no further notice for hearing was issued. And Lord, most importantly, on 5/5/22, as I have already pointed out, the complainant did not appear on his behalf. His authorized representative appeared. Now, my lord, kindly see, the verification report was submitted on 28/9/22.
Verification report submitted on?
Page 39, it was on
Correct.
28/9/22.
Yes.
Though the FIR is dated 14/9/22.
Hmm.
And the same day it was registered. That means, my lord, there was no application of mine.
Yes.
Now, my lord, now most important is Lordship will kindly take note of it. The allegation is on 5th, demand was made as per the SP. As per the complainant, demand was Well, the most important part is how can the superintendent of police be so callous that he tugs out a date which is not even mentioned by the complainant? I'm a complainant, I'm alleging this is what had happened. And it's similar, there is no there is no material to establish that. That is why they are saying all this. Now, my lord, is there any witness who said that prior to 24/8/22, there was any previous demand?
Okay.
There is no version from the side of the prosecution that there was a demand prior to 24/8/22, as the superintendent of police would like to say. So, art is not fatal, Milord. End of the day, Milord, the trial court is not a post office, as Supreme Court has said. When it comes to framing of a charge, there must be grave suspicion, as distinguished from mere suspicion. It is only when there is a grave suspicion, then only will the trial court would be justified in framing a charge. Otherwise, trial court is not within its competence to frame a charge.
Yes.
Now, my lord, most importantly, in this case, my lord,
Mm.
there was no transcription also.
Okay, no transcription.
Yes, no transcription has been prepared by CFL Delhi because they say they don't have the facility. By keeping the phone in loudspeaker, you cannot save everything, my lord. For example, if a lordship would kindly come to page number 273, my lord. Yes. Please come to
Page 273.
see. They give a report,
Hmm.
but can you see on page 273, Roman 7?
Yes.
The facility of preparation of transcription does not exist in physics division of this laboratory.
Hmm.
Senior scientific assistant.
So no finding was given.
Given, probable.
Where is that? Where is
Yes,
that?
yes. Please come to page 270. Towards the bottom, Milord.
Yes.
Hence, based on the similarities found in the question voice of suspected speaker and sample voice of known speaker, it is opined that question voice of suspected speaker marked exhibit so-and-so are probable voice of Raju Saktivel, whose specific voice is marked in so-and-so. Look, this probable business will not do. I'll place the judgment of this, Milord. Now, Milord, admittedly, Milord, it is a case where
Yes.
there was no spot recovery.
Absolutely.
So therefore, Milord, section 17A ought to have been followed. Section 17A has not been followed.
Hmm. Yes.
Now, Milord, I'll place two judgments, Milord. Hey, that's why I said, Milord, it's not a very long matter. So open and shut, please.
Yes. Yes.
Now,
Should not be much complications.
yes. 1977, 4 SCC 39, Milord. Milord, please come to the page 41.
Please.
41, Milord. In the third page.
Yes.
41, part of para 4.
Yes.
Please come to the last 5 sentences, Milord. At that stage, that is 227 or 228, Milord,
Hmm.
the court is not to see whether there is sufficient ground for conviction of accused or whether the trial is sure to end in his conviction. Strong suspicion against the accused, if the matter remains in the region of suspicion, cannot take the place of proof of his guilt at the conclusion of the trial. So if there is a mere suspicion, then it will not. What you need to have is a grave suspicion. But at the initial stage, if strong suspicion, which leads to the court to think that there is a ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is not sufficient ground for proceeding in accused. The presumption of guilt of the accused, which is to be drawn at the initial stage, is not in the sense of law governing trial of criminal cases in France, where the accused is presumed to be guilty unless contrary is proved. Now this is important. But it is only for the purpose of deciding prima facie whether the court should proceed with the trial or not. If the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in a cross-examination or rebutted by the defense evidence, if any, cannot show that the accused committed the offense, there will be no sufficient ground for proceeding with the trial. My lord, going by the materials of the severe authority of prosecution as on date, my lord, without subjecting it to any cross-examination, if it leads to a grave suspicion, then only when, my lord, a trial court will be justified in framing a charge. That's why, my lord, there are following this, there are so many other judgments. The common thread which runs in all the judgments is trial court is not supposed to behave like a post office. Trial court must apply its mind and find out whether relevant considerations are there. What are relevant considerations? Whether materials which constitute the offences are there. In the absence of it, my lord, it's clear-cut case where it will be justified in not framing charge. Then, my lord, on the point of that, my lord, tape recorded version,
Yes.
please come to para 23.
The other case,
Yes, other point. Sir.
the Mal,
Other case, yes.
the Malkani.
471.
Para
Para 23.
23.
If recorded creation conversation is admissible, provided first the conversation is relevant to the matter in issue. Secondly, there is identification of the voice. And thirdly, the accuracy of the tape recorded conversation is proved by eliminating the possibility of erasing the tape record. A contemporaneous tape record of a relevant conversation is a relevant fact and is admissible under section. It is
Just a.
It is also comparable to a photograph of a relevant incident, etc. The basic thing is, my lord, these are the three components which are required to be proved. Recorded conversation is admissible provided it is relevant. 2, there is identification of the voice, it is not there. Thirdly, accuracy of the tape recorded conversation. My lord, facility itself was not available in the laboratory. Where is the question of relying on it? They themselves say they do not have the facility, my lord. That probably will not do, my lord.
Yes.
Now, the other point which I would like to, my lord, argue with you,
Just take a look at the-
the sanctioning part.
Yes.
Lord, it is said, my lord, that sanctioning authority must have due regard to all materials, including complaints.
One second.
Yes.
Yes, yes, yes.
As a proposition, my lord, sanctioning authority must have due regard to all materials, including complaint, FIR, verification report, evidence, material, and strike a balance between public interest and protection available to the public side. Now, I'll place a judgment on that, my lord. You cannot just mechanically give, my lord, it. Look, after reading, I'll hand over the copy.
Yes, yes.
This is Miller 2014,
20,
14,
14,
14 SCC
14 SCC,
295.
295, yeah,
Paragraph 16, Miller.
para 16.
Yes. I'll just hand it over. Miller.
Sure.
In view of above, the legal proposition can be summarized as under. Prosecution must send the entire relevant record to the sanctioning authority, including FIR, disclosure statements, statement of witnesses, recovery memos, draft search sheet, and all other relevant material. Record so sent should contain the material document, if any, which may tilt the balance in favor of the accused, and on the basis of which competent authority may give sanction. The authority itself has to do complete and conscious scrutiny of the whole record so produced by the prosecution independently, applying its mind and taking into consideration all relevant facts before grant of sanction, while discharging its duty to give or before discharge sanction. The power to grant sanction is to be exercised strictly keeping in mind public interest and the protection available to the accused against whom sanction is sought. So, Milord, I'm handing over this copy.
Yes.
There's one more judgment, Milord, that I will also rely, Milord, that is on the scope of a very famous case of Milord, 1979, pre-SCC, page 4, Milord.
Yes.
Milord, this is on the scope of Milord, what do we call it, Milord, on 227 and 228. Milord, paragraph 10, Milord, I'll just hand over. Milord, the law was summarized. I'll just hand over after I read it.
Yes, yes.
Thus, on consideration of the authorities mentioned above, the following principles emerge. That the judge, while considering the question of framing charge under section 227 of the code, has the undoubted power to sift and weigh the evidence for limited purpose of finding out whether or not a privacy case against the accused has been made out. When the material placed before the court disclosed grave suspicion against the accused which has not been properly explained by the court will be fully justified in framing charge and proceeding with the trial. The test to determine a prima facie case would necessarily depend upon the facts of each case, and it is difficult to lay down a rule of universal application. By and large, however, if two views are equally possible and the judge is satisfied that the evidence produced before him, while giving rise to some suspicion, but not grave suspicion against the accused, he will be fully within his right to discharge it. That in exercising the jurisdiction under section 227 of the code, the judge, while under the present code is a senior and experienced court, cannot act merely as a post office or a mouthpiece of the prosecution, but has to consider the broader probabilities of the case, the total effect of evidence and document produced before the court, any basic infirmities appearing in the case, and so on. This, however, does not mean that judge should make a roving inquiry into the pros and cons of the matter and weigh the evidence as if he was conducting a trial. So at that stage, court will not behave like a mini trial, but must test the material feature brought by the prosecution, whether a prima facie case exists without subjecting the materials to any cross-examination. If on this, my lord, there is only a suspicion, as against a grave suspicion, then court would be justified in discharging the accused.
So two views, I mean, if two views are there, then other views, I mean,
Yes.
yes.
Paragraph 10 of the judge. Therefore, my lord, to sum up my argument, my lord, it's not a very difficult case. My lord. First, my lord, as I have already submitted, section 17 a protection has been denied. While giving sanction, it was very mechanically given. It could not have been given, my lord. And if they would apply their mind, there is no question of giving a sanction. Thirdly, my lord, the sheet anchor of the prosecution's case is the complaint. Complaint says on 24 822, when the complainant met the petitioner at his office, the alleged demand was made.
Yes.
Now, my lord, question is whether the materials that the complainant was present on so and so in the office to offer the bribe or to take the demand for bribe which he refused. And on the contrary, my lord, the verification report of the superintendent of police says no demand was made on 5th. So on these facts, my lord, is a my lord very senior officer, my lord.
So whether charges can be framed. Yes.
And my lord, it's a case where there is no demand, no recovery, nothing.
Only that this
That's all.
complaint part.
Yes, therefore, my humble submission is that so fifth case where lordships will interfere with the order and give a quietus to the case.
Yes.
I permission, I have.
Yes, yes, sure.
Lordship will hear the
You,
matter.
you have filed a written objection. no?
Yes, your Lordship.
Yes.
File the written objection.
Mm.
To start with, Lordship, though today I don't have the statement of the PWs who has spoken with regard to the incident. However, in the matter with regard to 482 of CRPC or 528 of the BNSS, while applying this section, the court, this mini trial cannot be done here. The issue which are raised by my learned friend is all with regard to the issue for cross-examination, your Lordship. Now I am coming to the first, this judgment. This judgment is given by our Supreme Court on 618, wherein Dr. Raju Setiwal, he is the petitioner, your Lordship.
Mm.
He himself is the petitioner, which was dismissed by this High Court. Same issue has been raised, your Lordship. And when, during the pendency of
What is this case?
they have come before this honorable court during the period 2023.
Hmm?
I have collected from the website of the High Court. So they have come, they have filed with the 482, your Lordship. In the second page.
They approached this court earlier.
Yes, your Lordship.
Hmm?
So this has been hidden somewhere, but this is available on the record.
One second. 1 second. So earlier you came for quashing of the affair, but you did not say anything about this. Oh no, obviously it's in a different footing because now they have challenged the charge.
Framing of
Earlier they came for the affair.
FIR.
But you should have mentioned this.
But at that point of time, a charge sheet has been filed. They could have come with the additional affidavit. They could have come with the additional affidavit. And this total order is dealing with the issues and all the judgment also, Lordship, and based on that, this petition was dismissed. And if I'll go through, it will take a bit time, but I will have to. And then I will confirm.
Then we'll keep it parted.
Yes, sir.
We'll keep it parted and we'll post it.
Then I will come with the other issue with prepared.
We'll post it on
May I?
26th of March. See, you should have mentioned about this. Please tell Mr. K. Chaudhary also, because there was a criminal petition filed earlier. Against the FIR, whether he is aware or not. You are not aware? How come? I mean, your client hasn't told you. Later on means who was there in the earlier?
So far, I have, my friend has said that he has engaged Mr. Ken Chaudhary.
For this matter only, I have engaged.
So
For
he,
the discharge, again, the discharge application, that include order, that is engagement.
You're correct. I mean, you were not aware of this petition.
but the party is supposed to tell them, party is
Correct.
hiding.
How can,
It
how
is his
can, how
duty.
can you can
He is a
hide this?
commissioner
How can you hide this?
and he is taking the appeals. And he is also trying the cases, sitting as an appellate court, trapping of the court in the
But,
appellate.
but,
tribunal.
I mean,
No.
whatever you have challenged the same FIR on the basis of which the charges has been framed. And you have not stated anything about this to this court. Mr. Chaudhary may not be knowing it also. I don't know. But I don't know. But you talk to your client. I mean,
But
yeah,
the
I'll ask him to come himself otherwise.
But the party being a commissioner.
He's such a high level Indian Revenue Service officer. Being an Indian Revenue Service
These are
officer,
the top,
if he's hiding this fact, I mean, I'll see like whether there is any statement made on this.
these are the top post of the Indian.
Whether any statement
Administrative
made
service.
about this.
I have not found your lordship, otherwise they would have definitely annexed the, I have not found anywhere.
Oh, no, they have mentioned about this.
Let me.
I think they have mentioned about this. 6-1.
Discharge petition, I think. Final impugn order 625 is annexed.
I think it is somewhere there.
No,
FIR, then
no. Complaint is there, format of the FIR is there.
Final report.
is there.
the discharge petition, what is this?
Discharge petition, it is their petition.
Huh? 174. Hmm?
This is of Supreme Court. Yes,
This is different.
and in the Supreme Court also it is dismissed.
Not issue. Because actually, that is after, actually, he might have gone to Supreme Court. From Supreme Court, there is order.
No. I mean, forget about this. I mean, about this petition, whether you have stated before this, stated about this. I mean, where is F? F is.
It is the order dated 24, 2024. It is not there. Thereafter, grounds are there. No 24 order is annexed. Your Lordship.
Who has drafted this? No mention about this case.
No mention. And only Supreme Court order is there.
Yes, serious. SLP is different. Is this the order? High Court's, where is the High Court's order? You have not stated anything about the High Court's order. Where is the SLP you're talking about? Page?
Page 274. 274. 274. And it has been withdrawn. And this is the order of 37/2024. And High Court order is 24/5/24. High Court order is 24/5/2024.
Yes.
And thereafter, they have gone to Supreme Court. That is the order of 37/2024, Your Lordship. Immediately after dismissal of this case,
So this was the, upon hearing the so-and-so, the council applying for the business 6 leaves to withdraw. They have withdrawn it.
yes. Maybe subsequently it happens that they realize if some adverse will come, then they are not going to get any relief in the trial court. Usually it happens.
But this is not done. This should have been mentioned. Anyway, I mean, we are keeping
One
this.
cause of action, that is with regard to the quashing of the FIR, that has been already decided. Court has given a full-length judgment to that effect, relying on.
No,
all
that is on FIR, but this is
that-
on
yes,
a
arising
different
out of
footing,
that
but
same-
they should have mentioned about this. That's, this. Yeah, I mean, you should have mentioned about this, that while, when the FIR was filed, you came before this court and this court rejected this, dismissed this, that you should have stated here. Okay, heard Mr. K.N. Chaudhary, learned senior counsel, assisted by P.K. Kolika, the P.K. Kolika, the learned counsel for the petitioner. Also heard Ms. M.S. M. Kumari, the learned special counsel CBI. Matter remain part heard. Let the matter be listed on 26th,
Let it be on 27th, Lordship.
20th Friday, it will be difficult. Then 31st,
Much of it.
31st
Much
March.
obliged.
Okay, heard Mr. So-and-so. Heard Mr. Huh? A. Nayak, the learned counsel appearing for the petitioner submits that, paying for the accused applicant submits that on the instruction, he wishes to withdraw the instant AV application, prayer is allowed. If the instant anticipatory bail application is dismissed as withdrawn.